May I please? Lordship, I beg to mention item number 27.
Wait.
Lordship, there is some progress, Lordship.
Excellent file this one. You are for the petitioner.
Lordship,
27.
arrear of salary is supposed to be released.
Yes, why do you want an adjournment in this?
Lordship, already his suspension period has been regularized, and only that will arrear salary.
An adjournment in the matter.
Lordship,
Why is an adjournment sought for?
Lordship, authority may release the amount.
Can you withdraw it? Go ahead.
Lordship, after and release.
Item number 20.
7.
The prayer of Mr. L.R. Mojumdar, London County for the petitioner. Matter stands adjourned for 4 weeks. Wednesday to list this matter again for 4 weeks.
All right.
Yes, Mr. Singer.
May it please, Your Lordship. Item number 20, Your Lordship. I'm no more appearing in this matter. The client has taken back the plea, Your Lordship.
File application before the registry.
I have already done it, Your Lordship. That is
Fine. When the matter comes up, nobody is there, we'll dismiss it.
May please, Your Lordship. Item number 40, my lord. 40 along with this take up matter 41. For us 14, my lord may not take it.
40 and 41.
Yes, my lord. That's some bank matter. May it come up for hearing, my lord, sometimes in the month of May.
Some day
Yes, my lord. That is what take up.
I
I will inform the petitioner. The
40 and 41 risk before any other bench without.
my lord, can it be in any date? Maybe
I can't answer.
More
Yes.
flesh.
Your Lordship, I would like to mention item 6 and 8. The conducting council has some personal difficulties.
What is that nature of the personal difficulty?
Your Lordship, I'm
Then
unaware.
ask him to be here. He's here in the court.
No, he's not.
Mr. Gugoi.
I dig over.
Matter was kept today for final disposal.
I'll inform him.
Seven months.
Item 7.
Judgment given. The
my lord.
division bench had repanded the matter only on the count that Kushwant Singh, Kushwant Parmar,
Kusan be permanent.
required that there should be a willful finding that the absence is willful.
Yes, in the inquiry report.
Inquiry.
By the
It should
inquiry
be.
officer.
Well, I'm sorry, that judgment does not hold water any longer.
But my
It
lord,
has been gone into in the subsequent case sometime in 2017. I'm getting the judgments.
my lord.
2017, Chennai Metropolitan. Huh? Para 14 or 15 therein. That judgment is no longer good law. It says that that judgment should be restricted to the facts of that case.
Yes.
So in that view of the matter, here admittedly, there is no material to show that you were prevented from attending your duties.
Yes.
Even your medical certificates does not support.
That's correct.
So we'll have to dismiss it.
Just 2 or 3 submissions, my lord. My lord, once again, my lord may look into the inquiry report.
Page 37.
Correct. Inquiry report, my lord. So for the page number 39, finding of investigation, my lord, last second paragraph from the, my lord, below. On the basis of witness number 1, 2, and 3, Constable Pankaj Besbora was found to be obedient to his duties, but no information could be found as to why he absconded. As per the version of the accused, he absconded and remained abscond owing to his mental stress or illness. He took treatment from a general doctor, but he has no proof as to whether he has suffered from such disease or has been suffering from it till date. My lord, next, my lord. On the basis of evidence numbers, after Constable Pankaj Besbora has been served a notice by IO, he appeared before the IO at the preliminary stage of investigation, but on 19/7/2011, he again absconded before the completion of the investigation, and after that, he neither appeared before IO nor communicated with him. Now, kindly see the suggestion, my lord. From the statements of accused and other documents submitted in connection with search level against so-and-so, and as the accused appeared before IO after he had been served the notice, but he again absconded before completion of investigation, it seems that the Constable Besbora does not want to rejoin the force, my lord. So
That is just
my-
a way of projection.
cannot.
That is just a way of
Let me come.
projection. That's all.
Yes, please do.
That's just a way of projection.
Yes. Now, my lord, my argument on the basis of the inquiry report is that, my lord, the colleagues, my lord, who were the witnesses, they, in fact, it was in fact, my lord, expertise, and they had stated the reason, my lord, as to why he was.
Where is that material to support that reason?
My lord, that's the thing, my lord. Now,
They say they have just expressed a doubt that
Yes,
this may be the one of the reason.
my lord, Military
But there is
state,
no material, but he has no proof as to whether
Yes.
he suffered from such disease or has been suffering from it till date.
initially, my lord, he was granted 30 days leave, my lord. All right, my lord. Prior to that, my lord, there is a situation he faced, he suffered some injury. They say he has not
Sir,
produced.
just show me some
Yes.
document to show that you are suffering, that you were bodily prevented from appearing for your duties. Much only.
Yes.
Forget the decisions.
Now, so far I was arguing the case on the basis of perma decision, my lord. And the perma decision, if that be so, my lord, since reason was before the inquiry officer who has failed to, in these peculiar facts and circumstances, that whether he, animals was on his part not to return the duty. Now, my lord, here after June 2010, they have accepted in their written statement, my lord, affidavit in opposition, that the petitioner voluntarily, just for a moment, my lord, kindly have a list of date. I'll try my level best, my lord. I do that copy. 2009, December, he suffered injury, my lord. And 6/1/2010 to 4/2/2000, he granted 30 days
From
leave.
2009 to 6/1/2010, you are in duties.
Develop his mental imbalance.
No, whether are you duty on?
Yes,
duty?
I was.
Right.
Now, my lord,
So there is no mental ailment till now.
in that period, that was not poker. Now, my lord, thereafter, they granted leave 6/1/2010 to 4/2/2010.
So from 4/2/2010, you
My
are
lord.
absent.
Yes.
This 21 is a wrong date. 14, serial number for 14/10/20.
Oh, this is the wrong list of data.
It should be 2010.
My lord, it's a wrong list of data I have given.
Intimation to join. A reminder.
Yes.
Petitioner join duty. It cannot be 2010.
Now, my lord, in their affidavit, they have
okay,
accepted, my lord.
Petitioner again remained absent.
Yes,
Petitioner declared deserter.
my lord.
11/1.
Malad, prior to 1410, Malad, there is a date, para 7 of their petition, affidavit, Malad. They stated further his parents brought him to the unit during the month of June 2010. June 2010, he himself came.
Page.
Page, Malad, this is 78 of their affidavit, Malad, para 7. That from the middle, Malay started like father, his parents brought him to the unit during the month of June 2010 and para 7. And after serving 4 months in the unit, he again deserted from the colony line on 14/10/2010. But he never intimated a mental condition during 4 months. Submitted any medical document related to treatment. Neither given information. He has not given information. Now, my lord, during the course of inquiry, my lord, he again appeared before them, my lord. 1/7/2021. It is reflected in page 49 in the writ petition, my lord. 1/7/2021, page 49, my lord. Page 49, para 5, my lord. In the middle, it is reflected, my lord. He reported back at his own on 1/7/2011.
Intermittent reporting, but you have stayed away without justification the whole period.
My lord.
Just show that the period of your absence was justified, that's all.
And my lord, after that, my lord, that for that period, he was suffering and he was treated in a local, my lord, medical. That one certificate I have enclosed, my lord.
So was it given to the inquiry officer?
No, that was, that my, I have,
Will not take for granted.
yes. Now, my lord,
Your only thing here is LGBI hospital certificate, which again does not reveal that you had
That
any
date.
mental illness.
correct. And now, my lord, the mother at the, after they received the, my lord, termination order, mother communicated to the, my lord, authority. And the authority intimated the petitioner's mother that, okay, so far this medical ground is concerned, you have stated that on medical ground he could not join. That will be considered by the appellate, you file appeal. I file appeal.
Where is that letter?
Yes. Para 13, they have, my lord, mentioned that, my lord.
Come.
Para 13, page 83 in their affidavit in opposition, my lord. Para 13, my lord. The submission petitioner that his mother has conveyed the reason for absconding the duty concerned. It is submitted, Ira Besburua, mother of the petitioner, has submitted an
This is
application.
different thing altogether. That you have an opportunity to file an appeal, you file an appeal.
No,
But
my lord,
we,
yeah.
as far as I am concerned, this is closed.
And so far that is concerned, my
Okay,
lord,
Toby,
it is,
okay,
it is
Mr. Das.
also correct,
Das,
my lord.
your the statement here is that the projection made is that you are under medical treatment.
Right,
You are having mental ailment.
my lord.
Just show me some material to support that.
Uh,
Because you said to be taking treatment at LGB Regional Law Institute of Medical Science, Medical Health.
right, my lord.
Show me some.
My lord, on that point, my lord, he has stated in the petition, he lost entire, my lord, document. Now, since the petitioner was suffering from, my lord, mental imbalance, my lord, he did not know what
Not
to do.
apparent because the materials that you have brought on record reveals the other way.
My lord, one judgment I have submitted on this count, my lord.
Come to page 20. We'll get judgments. We'll first let us
Yes,
get over with the fact.
my lord. And that later, my lord,
You come to 26/11/2016,
my lord.
page 27.
Correct petition, correct. My lord.
Here, this is the certificate of LGBI.
Right.
Nothing is here.
Yes, for a particular period, he was under their treatment, my lord, it is not disputed. But now he is not suffering. At the time of issuance, he was not suffering from such disease.
No.
That is.
I'm sorry, that is not the certificate. Certificate is something more.
Certificate state that he
Was
was
admitted in 28/10/11.
Yes,
So that is the period when you were
yes,
corresponding to that unauthorized absence.
right.
But he got discharged on 7/11.
My lord.
However, in evaluation, no psychiatric aid was found during the period of his observation.
My lord.
So at that period, you did not suffer. And those are experts who are saying that. How can we go by your statement? Your self-presumed mental ailment. That is not permissible.
And
Anything more?
my lord, from the judgment itself, my lord, there is a judgment of this honorable court also where I appeared, my lord, and there also, my lord, that Fulagogoi Sutia 2006 1 GLT 704.
2006?
2006 1 GLT, my lord. 704, my lord. If that is not there,
No, it should be, it should be here. It should be.
I have copy, my lord.
It should be here. Ulla? It is here. It is all here.
There, no. Here, kindly see, my lord, the para 10.
Just one, let me just find. Para 10.
Yes.
Huh.
Here also it is another discipline force, my lord. Now, para 10, my lord, here it is stated, and in view of the Supreme Court judgment, if a notice giving intimacy of putting to a person warning, either asking him to do or in the restraining him from doing that act. Well, if a, as stated by the my lord, witnesses, this is not disputed that I was not suffering from mental illness, my lord, before the inquiry, my lord. And in that condition, even if some notice is given, I would not know what is the consequence of this notice.
First establish that you were suffering from mental illness.
Uh,
The consequences under IPC will also follow.
Now, next
Here
para,
the materials on record was, it established that the person was suffering from mental ailment. Accordingly, the court said he does not know the consequences. How can you do it?
this is right. Now, while my lord appeal,
So this judgment is not helping you.
and that para 11, this the standard of proof that is there, my lord, on the basis of the materials available
Come,
before
read
the
para 11, read para 11.
Yes. The basic search against the petitioner was that unauthorized absence with effect from 28/4/2006. From the documents placed on record, it appears the petitioner was suffering. My lord, these documents were placed at in the court, my lord, not because this was also ex parte.
A mental ailment and was under treatment. Okay, I accept that. Show me. You show me here.
That one
The
document,
document that you have produced goes against you. That
Well-
you have willfully remained absent from your services.
my lord,
And
that-
the suggestion made in the facts and circumstances by the inquiry officer, apt.
my lord, that whether from the materials available before the inquiry officer, this is his duty to prove it, my lord, in accordance with law that
And this judgment is also based on Khurshwan B. Parma's
yes,
case.
yes.
But Khurshwan B. Parma now is said to be a law laid down in the facts of that case. It cannot have a further application.
My lord, what I understand, my lord, in that view of the matter, my lord, since the division bench of the honorable court has passed this order, and can it be, my lord, placed before the, my lord, honorable court, my lord?
Why should I? Why should I?
My lord, this is my submission only, my lord. This
I don't have the jurisdiction.
because, my lord, they are
Now
in
the
the
court
same
has
case.
remanded back the matter. The
Yes.
matter is open.
Right.
We will take a call and we will discuss
Correct,
of
my
the
lord.
matter.
So, on the basis of the observation made and the subsequent judgment that that was not there at that time, my lord. Now,
The very division bench order is of
yes, my lord.
23. That
Correct.
judgment was very much available. It was not placed, that's a different thing altogether.
And moreover, my lord, there's another, my lord, judgment that I placed, my lord, Dharmeshwar Seal, the writ appeal number 52 of 2019.
What do you want
Here-
to say?
Here also, my lord, that discipline for CRPF, my lord, 414 days delay. Now, the honorable court, how deal with, my lord, para 14, the judgment of writ appeal number 52, my lord, para 11, my lord.
Come to para 7 first.
Yes. Per contra, Mr. So-and-so learned counsel representing the respondent repetition supported the order rendered in learned single content.
All these judgments have been passed on the basis of Kushwan B. Parmar. Right? That there has to be a further finding that it will be willful. But Supreme Court has said that is not called for. Only thing now that you got to show is that your absence was justified.
To
that
that
you
effect, my
cannot-
lord, there's only one document, my lord, by way of additional affidavit I have filed before this honorable court, my lord, for your satisfaction, lordship. That document, lordship will find at page
145.
145. My lord, this is the doctor where local initially, while he came from the, my lord, unit, my lord, that for a particular period, he was under his treatment, not as a mental patient, my
I'm
lord.
sorry. This certificate cannot be given any cognizance
Yes.
because if you were suffering from something, this is not mental illness.
No, no,
This is head injury.
yes.
You had reported for duty. You had a very good facility there. You should have gone there.
My lord, can it be related with the, my lord, witnesses, my lord? Subsequently, the witness, I developed,
Mr. Counsel, at this point of time, when these certificates were issued, you were not suffering from any
no,
mental
no,
illness.
later on.
It came on later on.
Yes.
So that is not established. The best authority to do that was the LGBI hospital.
My lord, moreover, my lord, what I submit, my lord, this kind of illness, mental illness will not develop in a couple of days. It will
Say it has developed, say after
Yes.
5 years, 10 years.
No, not 10 years. my
So,
lord, it,
but if it is developed after 10 years, how could you have remained absent at that point of time? That means you must show that you were not in your senses. You were not in a position to appreciate. Your conduct does not show that. You came, joined, and again you felt bored, went away.
well, in that case, my
Your
lord,
discipline force personal.
may I review my submission stating that, my lord, that in a case of deserter, while declaring deserter, thereafter I myself came to the force and there is no animus on my part not to join the duty. And they have allowed me to join.
Then what did you do?
No, no, my lord, let me.
Then what did you do?
I came and joined.
Then what did you do?
Yes. Thereafter, my lord, so far deserter is concerned, Rule 9F of the CRP, Section 9F CRPF Act, my lord, this is, my lord, heinous crime. And they can impose me punishment for undergoing imprisonment. They,
In lieu of that, in section 11, in
yes,
lieu of
no,
that,
that
they have
thereafter,
passed this on.
thereafter, my lord, Section 10M, absent without leave, overstay. So this categorized as less heinous crime, my lord.
You go to 27.
No, that's
Rules.
correct. My lord, they will initiate
It is
departmental
now-
inquiry.
Now settle that 11 under 11, 10 and 11, they can
My lord-
impose a major penalty
My
also.
lord, I pray for your lordship, take a holistic view in this matter.
No, you
because-
give me
because, my
material-
lord,
Mr.
let me
Das,
complete, my lord.
mere saying holistic view will not do.
No, no.
I cannot base my judgments on air. You give me the material, I'll take it into.
Primary material is the division bench. If lordship distinguish the
Division bench
judgment, my lord.
Division bench judgment
lord-
remanded the matter
Yes,
on a law which is no longer a good law.
but one thing
I'll have to
remain
take
there.
note of that.
One thing remain there, my lord. That procedure irregularity is there because the
Show me.
division also
Show me
say.
that procedure irregularity.
No, my lord. In the order, my lord.
Show me. Show me the procedure irregularity highlighted.
Yes, that is there.
Yes, please.
Judgment is it? Yes. Para 9, page 7, my lord, first top line, my lord.
Hmm.
Learned Singhal observed that the petitioner has not made challenge to the dismissal order on procedural ground irregularity. The observation appearing in paragraph 13 and 14 of the impugned
Do you
judgment.
know what that procedural irregularity was? That the inquiry officer did not record a finding that it is willful. That's the only procedural irregularity. Nothing else. That is taken care of by the subsequent decision of the Supreme Court, because that is in relation to Parmar.
Yes.
We do a small bit of homework also.
And our endeavor, my lord, to my lord,
You
face
give
the-
me that material. I am
Malad,
there with you.
because this was expertise also.
Mr. Das, I only want one fact from you, some material to show that the petitioner was not in a position to join because of his mental imbalance. I'll use it, the word mental imbalance.
My lord, for that purpose, my lord, lordship may consider page 145, whereby he was treated for injury.
That injury was not of a nature
Yes.
because of the subsequent events that he could have remained out of duty.
My lord, since this was expert and if other witnesses had not stated the reason, I would not have argued the case, my lord.
Fine.
Other witnesses have stated, owing to his mental stress or illness, he did not know. So on that count, my lord, I was my lord, helping the matter, my lord.
And if you had this Gautam Nath treatment, you could have placed this very well, placed this before the inquiry officer also.
My lord, he actually, I have also somewhere stated in my petition, he lost entire my lord, evidence, my lord. So that's the problem.
And how did this Gautam Nath issue this certificate with regard to 2011 in 2024?
My lord, he was in duty at that time, my lord. Now he retired. While he
How did he remember? Because he might have treated
some documents-
thousands of patients.
some
So
document
what
was
is
there.
that basis for this certificate?
My lord, he stated that he was treated under him.
No,
at
is
that
it from
point
his
of-
knowledge?
No,
Because
no.
he's giving particular dates.
Yes, yes.
But he does not say
Yes.
that you were at that point of time
Disease
from
of
some
suffering
mental
from
illness.
head injury only. Head injury is there.
And in terms of your we are looking for something so that we can give this man some relief.
Yes, my lord, that's the case.
But the problem is you're not supporting us.
My lord,
You're
my
not- you're
entire
only
argument,
saying-
my entire submission was that only, my lord.
You have
My
built
lord,
up the
in view
case
of,
on the basis of
no, my
Parmar.
lord. My lord,
Okay, page 45, the period of treatment is
it's 145. 16/10/2010, my lord, to 29/6/2011.
16/10/2010 to
29/6/2011.
and the second period
22/7/2011 to 24/10/2011, my lord. My lord, I am at the mercy of your lordship, my
No.
lord. He has.
okay
Of
okay
course,
I very
If
much
some-
agree.
If some my lord, relief can be given.
I very much agree.
My lord.
Now this treatment, this is the only document that now it is there.
Yes,
So this treatment started on 16/10/2010
my lord.
and on that day
Yes.
you were unauthorizedly absent.
Correct, my lord.
And you project that because of the injury that you sustained in 2009, by that time you had become mad or you had lost your mental imbalance.
Balance, yes.
Where is that in that certificate?
No, that is not there. He was
So the
treated for mental injury.
Injury that you suffered in 2009, that injury will not continue till 2010 or till 2011 because there is no material.
Yes.
If it is a head injury,
Well,
it is
I-
not something which can be treated by a doctor in his chamber.
My lord,
When you make out certificates, you got to think about these factors also.
my lord, one submission, my lord. This is, but this is my knowledge on the personnel. I have also seen the person in my chamber. And yes, his cut injury is there, my lord.
If that would
Yeah.
be the law,
That
Mr.
is-
Das, then
This is of
we would
record,
lose
my lord.
our
Yes.
prominence
Yes.
in the legal system.
In view of the, my lord, nature of proof and the, my lord, so far, one judgment that just has come to my mind, that in a case of unauthorized absence, also, although it is a misconduct, but then, my lord, dismissal from service or termination is excessively,
You cite your judgment.
yes, excessively, my lord, harsh, my lord.
Cite your judgment.
Union of India versus R.K. Sharma, my lord, para 11.
Our High Court.
No, my lord, it is from the Honorable Supreme Court, my lord.
Okay.
Here was,
Union of India versus R.K. Sharma.
yes, one judgment I am placing. So on that basis, my lord, the lordship may can take some favorable view, my lord, towards the petition, so that he can get some relief, my lord. Para 11, my lord.
Mr. Das,
My lord.
this is not helping you. One, the power under 142 was exercised by the Supreme Court. Two, the period for which he was held to be unauthorizedly absent, all those periods were regularized. So I'll not burden my judgment with all this. Right.
My lord, some my lord, lesser punishment, my lord, may can think of.
Your conduct does not move this court.
But
Anyway, let us hear Mr. Chaudhary.
My lord.
Yes, Mr. Chaudhary.
Obliged.
You should be benevolent. That's what Mr. Das
My
is
lord.
saying.
Would have been benevolent, but then the period of absence is too long. Now, my friend wants to build up a case by saying that before he has gone on leave, he suffered an accident. Thereafter, he attended office for some time. And then he went on leave, and then there was mental imbalance. And he attributes his
That is not the fact. That's
Then-
not factually correct.
he wants to build up on that. But the thing is, had he met with an accident, suffered a head injury, there was a composite hospital, he could have got treatment. No, he did not do so. And the documents that my friend relies upon, I'll just take the cue of his document at page 145. And he says that he was under treatment of so-and-so doctor. In fact, the day when he produced this document, I had objected because this is a certificate issued in 2024. But then, if your lordship will see another document which he has annexed in his writ petition at page 22. If this is correct, then how is page 22 there? This is of 2011 also. This is pertaining to the same period. And then your lordship has also taken note of the certificate issued by the authorities. Now, this certificate at page 27, lordship will note that this has been issued on 26/11/2026. And the dates given here are based on some record of the institute that he had gone there. on 28/10/2011. This was given after the authorities has checked into the records. They did not find anything and he got discharged on his own. Now, whether such a conduct by a person belonging to a disciplined force can be condoned, Lordship.
Now you come to page 27.
Yes, on there.
He was admitted in the hospital on 28/10/2011,
Yes,
right?
28/10/2011.
Hmm.
And this is the same period.
Now if you come to page 145.
Yes, this is the same period. Within this,
28/10.
he was 16 from
Oh,
16
no.
to 20. I'm sorry.
He is out.
He is out. But the other one, page,
So this was at least made by reference to this. That much application of mind was.
I don't know.
forgot to take into account page 22,
2010.
11.
It is 2010. eh?
11, what's my registration number? Left of 9842 11.
This is 2011 registration.
Yes.
So he first went on 26/3 and thereafter he was
26 March.
March,
March.
26/3, 2011.
Yes.
And then he was there from 28/10/2011 for diagnosis and treatment. He was discharged on 7/11, after around 9 days.
9 days.
They say he was evaluated, he found there was nothing
Lordship.
and he never went back.
And during the inquiry, he was there for a few days. Then he again absconded. And so far as Lordship, his reliance upon the
So he went back on 26/3 only to get a certificate
yes.
and that went against him.
Yes. If your Lordship will, he was relying on minor punishment, provision of the statute. But if your Lordship will see, section 11 of the CRPF Act, I'll just take your Lordship through the opening lines. 11(1).
Yes.
The commandant or any other authority or officer, as may be prescribed, may, subject to any rules made under this act, award in lieu of or in addition to suspension or dismissal any one or
Of the
more of
following
the.
powers.
So he can,
You can.
and that is supported by a decision of the Supreme Court in Lordship. This is Ghulam Muhammad Bhatt. So that it has been discussed, Lordship.
And Mr. Das is not very seriously contesting that also. He is not seriously contested.
Parma, Lordship.
He is on par.
Is on par.
Anything more? You have already added to his troubles. Why?
No, I will not add further troubles to him.
Give me one thing. One, I'll put you back. But one, that shaking factor. Nothing.
No, cannot be developed this case. Now,
Okay.
my subsequent submission.
First thing, you give me a corrected
Yes,
list of dates.
yes, that is there. I'll just place it.
But
Malad, some relief maybe think over so for the petitioner is concerned in view of the fact
I
matlab,
don't
proof
have,
before the
see,
inquiry
Mr.
officer.
Das, I don't carry a baggage of goodies.
Malad, I would
The
not.
goodies are created or not created in the case only. I don't carry it with me. Heard Mr. B.K. Das, Learned Counsel for the petitioner. Also heard Deta Divade. Also heard Mr. R.K.D. Chaudhary, Learned Senior Counsel. And DYSGI, assisted by Ms. L. Devi, Learned Counsel, appearing for the Union of India respondents. So, hearing concluded, registry to list this matter again on. Our reason. 14.5.
Just, Lordship will just take note of one more sentence in page 27.
Hmm.
Following discharge, he did not come for
Yes,
any
that is
follow-up.
there. My lord, oblige, my lord.
The only thing I was looking for yesterday night was that some justification somewhere.
Yes.
What happened? Nobody is appearing.
Gogoi was there. He Gogoi.
After some time.
Yes, sir.
Yes, Mr. Das.
My lord, in this case, my lord, we have already filed a additional affidavit, my lord, that.
But
we
I
are
find
record-
that
Right.
in that additional affidavit,
My
you
lord.
have taken a plea that an application was moved
My lord,
for restoration,
My lord.
but that was not proceeded with.
but not subsequently, in this case, you also, you are allowed to withdraw, my lord. There is no order, my lord, from this court.
Where?
That I am not annexed, my lord. No, it don't.
Five, six, one, two.
No, it-
5612, 2008.
This is the order, my lord. This is the order, that 22/10/2019, my
Why
lord.
should not like?
My lord.
How can this be withdrawn when it was already dismissed?
The application, that was, my lord, the application was filed, my lord.
This writ petition
No, my lord.
was already disposed of
This-
on
On,
much before.
my lord.
And that dismissed matter, how can you be permitted to withdraw? This is a wrong order. Because maybe that IA was permitted to be withdrawn. How did this come? Because your IA never got registered.
That miscase was filed, my lord, that by then this a condemnation petition was also made ready, my lord, but it was not subsequent that it was not filed. That I do not know why it was not
Delay
filed.
condonation was filed. There was so and so.
My lord,
What was the miscase number?
miscase number, my lord. IA was 823, my lord, 2018, my lord.
But this case, 5612, 2008,
My lord.
which was dismissed
This
for
was
default,
for non-prosecution, my lord.
non-prosecution on 2-1.
The 2/1/2008, my lord.
No.
No, sir, sorry, my lord. The petitioner was not, sir. This is for default on 10/8/2015, my lord.
10-8, 2015.
15.
That order was never recalled by this
My
court.
lord.
So this order cannot be taken because this order is passed in a dismissed
lord.
writ petition.
That's it.
Possibly of no consequence. Mr.
Well, I remember that actually I have explained it.
No, if it was passed in the miscase also, miscase number given, or what's the miscase number?
That was
820?
Hmm.
823, 2018. Because Mr. Nas, the problem that I'm facing is a dismissed on non-prosecution is also a dismissal.
This, well,
So I can't touch it.
my only problem actually that your lordship has raised in by point, my lord, why it was not mentioned in the second petition about the filing of the earlier petition, my lord. There is the point.
No, fine.
Well,
That much we will not go. But the thing is, that writ petition is no longer alive.
The earlier petition, my lord.
So let's just have a seat. I'll just check it up.
Well,
So what exactly has happened? এটা share কৰিব পাৰিবা নেকি তো? ইয়াতে share কৰিব পৰা যাব না। না, এইটো বেলেগ।
in that case, my lord, that record, the earlier, the case record of the earlier petition may be a call for, my lord.
I'm getting it.
Yeah, my lord.
Getting it. Because if it has been restored
My lord.
and then permitted to withdraw, nothing like it.
No, my lord.
We can proceed to a clean slate. এই রেকর্ডটো ক'ত থাকিব 56122
In that case, my lord, let the matter be taken up day after tomorrow, my lord.
You need not wait.
Well.
You need not wait. এইটো ৰেকৰ্ডটো কল কৰি দিবাচোন 5 পাবানে আজি দুটা বজাত এবাৰ you need not be here.
Well.
I'll just go through the records.
Well.
And we'll fix it day after tomorrow.
Well.
You need not wait. 5612. Okay. Disposed of on 10/8/2015. যদি পোৱা নালাগে নালাগে Parmeshwar Das.
No.
The net is too slow here. It's something. Mr. Das, please have a seat.
Well.
8/23/2019. I see. ইয়াৰ লগত ৰেকৰ্ডটো আছে নেকি চোৱাচোন থাকিব F6 to it. Hmm? Oh. No, it was GR case. Yes. This is the order. That is why my doubt. Matter was restored. So now, Mr. Das, the field is open for you. You can argue on merits.
Right.
You got it?
Well,
So that writ petition was tagged with this, and then that writ petition, the IA
well,
was allowed.
well,
And the order was recalled and it was restored to file. Then you were permitted to withdraw that.
we don't want to.
Because by the time you had instituted this process. Yes. So that plea of yours, why did you take that plea? You are a party to that.
Your Lordship, that
In
matter,
your affidavit, you have taken that plea. Why? That is what got us moving like this.
no, Your Lordship, at that time, Mr. LP Sharma was there.
Whoever Mr. Sharma, your bank is the one who has filed this affidavit. Some order today. What is this stance you are taking?
Your Lordship,
You
regarding
wasted the time
restoration,
2 days of this.
no, regarding restoration, we have not been informed of.
How can it be not that you have not been informed of? LP Sharma, Learned Counsel for the Union Bank of India.
Because the original matter was looking after by Mr.
That
LP
the
Sharma.
other counsel who was junior so-and-so submits that the fact that it has been filed after 3 years, the applicant should not have been diligent. I've heard the Learned Counsel. So-and-so, accordingly in the facts and circumstances, the matter order dated so-and-so is recalled and WPC number so-and-so restored to file, subject to payment of cost of ₹1,000. Same shall be released. So-and-so IA is accordingly registered to list W. So after that, this case was withdrawn. And on the date the case was withdrawn,
Allowed to.
your
withdraw.
counsel was still there. It was in your presence, in the presence of the respondent bank.
Your Lordship, after Mr. LP Sharma has already been expired, and thereafter somehow I taken the records from him. Very
Your
recently
affidavit
we have
is
received.
misleading. Your affidavit is misleading. You have made a misrepresentation before this court. Okay, where is that statement that you have?
And affidavit was also filed by. That is, was filed on 20th 2018. On that affidavit, I am only working, Your Lordship.
Page?
That is, Your Lordship, earlier that running page is still one, Your Lordship.
Filed by one
That is LP.
Santanu Mondal.
Yes, Your Lordship. And that was restored on 14/6/2019.
Which one?
This IA of restoration of the earlier writ petition was passed on 14/6/2019.
When was this affidavit filed?
And affidavit was filed on 20th 11/2018.
And from where did we get that this was dismissed for default?
Yes, Your Lordship.
Okay, that IA itself.
Yes, Your Lordship.
Okay. So, Mr. Das, we'll take it up for final hearing and on merits now.
Well,
Also,
today or day after tomorrow, my lord.
whenever.
Let it be on day after tomorrow, my lord.
In terms of the affidavit filed by the respondents, this court had found that the petition had initially approached this court assailing the termination of his services by the respondent bank, by way of instituting a writ petition being WPC number 5612/2008. So accordingly, this court had wide order dated 26/3/2006 required the petitioner to explain as to why the filing of the earlier writ petition was not brought on record in the present writ petition. Also, the learned senior counsel, the petitioner has thereafter filed an additional affidavit in the matter. And the learned senior counsel for the petitioner, Mr. N.C. Das, learned senior counsel, appearing for the petitioner, has submitted that that WPC number 5612/2008, which was filed by the petitioner early and which was dismissed for non-prosecution in the year 2015, was subsequently permitted to be withdrawn by this court wide order dated 22/10/2019. On a further search made by this court finds, full stop. In view of the above position coming on record, this court had further made a search and has found that against the order of dismissing WPC number 5612/2008 for non-prosecution, the petitioner herein had instituted an interlocutory application being IA bracketed C number 823 of 2019, praying for a restoration of the said writ petition. A coordinate bench of this court, wide order dated 14/6/2019, had on considering the issues arising in the matter, proceeded to restore WPC number 5612/2008 to the file. So thereafter, the petitioner had withdrawn WPC 5612/2008, had prayed for withdrawal of WPC number 5612/2008, and the same was permitted by this court wide order dated 22/10/2019. The said prayer was so made in view of the fact that in the meantime, the petitioner had instituted WPC number 6329/2016, and the same was pending consideration. Considering, in view of the above position, although the present writ petition is found to have been instituted during the pendency, during the period when the order dated of 10/8/2015 was holding the field, however, considering the subsequent developments taking place in the matter, the present this court is of the considered view that the petition may not be considered view that it will not be permissible to non-suit the petitioner on this said ground. Accordingly, the present writ petition would now be considered on its own merits. Also, as prayed for by the learned counsel for the parties, raise free to list this matter again whenever it's convenient to yours.
Day after tomorrow, my lord.
After tomorrow will be difficult.
I leave it to your lord. Let be on a hearing day, my lord.
Nina Pari. It does. The hearing. Pistavana is. 7/5/2020.
Right. Published, your lord.
Time logo na.
One more time. Yeah, please, your lordship, that this matter is being conducted by P. Nayak, my lord, that additionally, so he is on legs in another court. Can it be taken up? after
We'll
some
take
time?
it up after some.
My lord.
Mr.
Lordship,
Majumdar,
Lordship,
you have made many prayers here.
Lordship.
Show me the decision of the Honorable Supreme Court, wherein the Supreme Court has said under similar circumstances that you got to maintain parity. That's the only way I can save you.
Lordship, please.
Otherwise, everything is gone.
Lordship.
By the time you came up before this court, 2012 decision was already there. That went to the single bench. Single bench dismissed, it went to the division bench.
Lordship, please.
Division bench following that Upenda's decision. So my hands are tied. The only way I can come in your favor is that if you can show that a right accrued to you on your juniors being
Lordship, I have that judgment, Lordship.
income tax
Lordship.
department judgment.
Mainly paragraph 8, 9.
Yes, Mr. Admittedly, he is from 86. Juniors done. Second round you go. His right there for a fair consideration was there. And it all happened before 2012. So we cannot ignore that. I do this for one case. There will be many to follow.
On that floodgate, Lordship, I'm relying on one judgment of 2007 Supreme Court, Lordship. Just I'm giving, Lordship.
Okay, you get your judgment. Let Mr. Naik come.
Lordship, please.
Wait, please, member. Praying for ending adjournment.
We can't make a senior wait. Yes, Mr. Why have you not informed him earlier?
But I don't have the file with me.
But you're fine. The registration is off.
Madam. Yes, sir, withholding the
paper.
my lord.
You have availed that chance beyond the. format
That
of
is
this
that is the stand of the university, my lord.
What do you say on that?
My lord, only problem is when it's actually money, the university has allowed me to appear in the examination, my lord.
That you have relied on the Supreme Court
My
decision.
lord, yes,
And they did it with open eyes.
my lord. In that case, actually, the university was directed to produce the record, the result of this money in a seal cover, my lord. That has also probably more, they have not produced, my lord. There's an order passed by the Honorable Court, my lord.
Where?
17-2-2021.
Huh?
17-2-2021. Order.
17 to 20
21.
2.
202.
17 to 2021, my lord.
21. 17 to 21. No, that is only the results.
My lord, result, my lord.
Result. Okay, fine. We understand that. But you were to first appear in the selection process. You had earlier approached this court, no?
No, my lord.
First time. So according to the affidavit, petition number 1,
My lord.
BA Part 1 examination in 2008. There are 2 petitioners, 3 petitioners.
Yeah, 4 petitioners, my lord.
Oh, okay. Petitioner number 1.
1, 2, and 3, my lord, they actually appeared in the, my lord, BA part 3 examination, my lord.
No, let us see first one.
Yeah, my-
If 2008, then passed 2010, then
BA on 2010 and part 2,
BA
2011.
Part 2, 2011 appeared. 8, 9, 10. 9, 10, 11. So you get 3 chances for each exam.
Each of the example.
So first one, petition number 1 took it in 2008.
Well,
So 2008, part 1, then he should have appeared for part 2 in 2009.
my lord.
But he cleared part 1 in 2010 and appeared for part 2 in 2011.
2011.
So 10, 11, last chance is 2012. And the first chance for BA part 3 is 2011,
Well,
12, 13. He's availing the third chance only.
It is a similarly situated case in Momi Bonik that came before your lordship only. That printed admit card we sent is to the college and the principal is to countersign it.
We are not concerned with that. We are concerned with this. Here, the third chance, first year, 2008, first part 1, part 2, 2009, normal, part 3, 2010, right? Okay, 10, 11, 12. Okay, okay. So 12, your chance expired.
sure.
So how do you get it in 13?
No, that is my actually my stand is my lord, when this all my application was scrutinized by the initially by the college, my lord. And after that the form was
Okay.
forwarded to the university, my lord.
So you are on the point, Mr. Sudas, that the applications have been scrutinized.
Scrutinized.
No objection raised.
No, my lord.
You appearing,
My lord.
following that Supreme Court decision,
My lord.
you will have to pick up.
My lord.
Any particular paragraph?
My lord. My lord, paragraph 9, my lord. Paragraph 9, page 6, my lord.
Okay. We'll hear, Mr. You need not be, you
Hello.
need not wait. We have heard you. If something adverse comes up, we'll fix the matter.
Right.
You need not wait. Otherwise, we'll dispose of
Right.
it.
Public,
Yes. Ask Mr. Fukon to be here. Mr. Das, you need not wait. Because if there is something adverse which comes up to our notice, we'll fix it up on a date subsequently. Yes.
Lordship, the petitioner, Lordship, I have filed a affidavit to, today, Lordship can.
No, what is the, whether any pension given to him?
Lordship, he
was
receiving. He is receiving because he was.
From that date of regularization.
Yes, sir.
2000. 2000.
2000.
1699. So he's
Yeah.
getting it from 169.
Yes, he retired on 31st June 2020.
31st June.
2020.
And he is given pension from 01.
Pension from 01.
06 19.
Yes.
Where is your
169.
affidavit? Yes, sir.
Yes.
What can we do for you?
Regularize his service, Lordship, from the date of joining, Lordship.
Show me.
Yes.
Show me. Yes. Tell me the facts.
Lordship, initially the petitioner selected under general category, Lordship. Lordship, but he was appointed under the category of STP, ST Hill, Lordship. Lordship, thereafter, Lordship, his service was regularization on Lordship 2302-2000 with effect from Lordship 1/6/1999. Lordship, thereafter he is continuing his service and he receiving a salary and other benefits. Lordship.
When did you retire?
Lordship, on 31/07/2020.
20. Now, your service thing was fixed on 23/2/2000,
Yes, Lord.
right?
Yes, Lordship.
Therein it said that your regularization will go back only till 1/6/99.
Yes, Lordship.
Why did you not make a challenge to that for 18 years? Say something. I'm here to hear you. That is why I asked Mr. Islam that he will not argue. You will argue.
Lordship, I am not aware of it.
Yes, Mr. Islam. And next time onwards, always prepare like this, all brief facts.
Okay, okay.
Yes.
This case, your lordship, the petitioner is a selected candidate. He was selected the reserve, but he was
Mr.
appointed.
Islam, just to cut the matter short, you were not selected and you were not within that range against the general category.
Yes,
So you were not considered. There was some vacancy in a ST post, so ad hoc basis they allowed you, subject to that post being filled up by an ST candidate. Did not happen, you continue. And in on 23/2, you were regularized. And that too only till from 1/6/99. You accepted that. Continued for around 18 years, then you approached the school.
Earlier he approached this had representation that approach.
You did not approach the school. Where is the
representation before the
And that is also in 2007, after 7 years.
70 lots.
But your right got fructified here in order dated 23/2/2000.
Initially, subsequently, he filed representation that he may be regularized.
So you're getting your pension from 199? Fine, we enjoy that. Call
This case,
Give us slip.
Yes.
due to fault of the respondent, he's suffered because
You allowed that fault to continue for 18 years without any, and that thing
it
said
is correct.
finalized.
It's correct because his earlier is not approached.
Heard Mr. S. Islam, Learned Counsel for Education. Also heard Mr. V. Chaudhary, Learned Standing Counsel, BTC, no.
Finance and taxation.
Taxation, Finance and Taxation Department, appearing for all the respondents. Oh no, or for the respondent numbers 1 to 6. Who is appearing for 7?
I am for respond number 3.
3, okay. Ms. S. Borua, respond number 3. Appearing for 1, 2, 4, 5 and 6, Chaudhary. S. Borua 3. 7, none appears for the respond number 7. The petitioner, by way, have your seats. By way of instituting the present writ petition, has prayed for a right direction upon the respondent authorities to regularize the services of the petitioner with retrospective effect, that is with effect from 2/5/1994, when he was for the first time engaged by the respondent authorities in pursuance to his selection for such appointment by the
Number 7.
central, what is that called?
Central Recruitment Committee.
Central Recruitment Committee. Also. As projected in the petition, the petitioner in the year 1993 was selected by the Central Recruitment Committee, Dhubri, for appointment against a grade 4 post within the government establishments. This is for all establishment or only for taxation?
No, Lordship, it was for all establishments.
For all government establishments. For grade 4 post available, vacant grade 4 post available in various government establishments within the district of Dhubri. Also, it is projected that the petitioner's name was placed in serial number 16 of the list so prepared of the candidates who were selected for such appointment by the Central Recruitment Committee. Also, while appointments were being made against from the said list against a regular sanctioned vacant posts, the name of the petitioner herein was forwarded by the Deputy Commissioner to Dhubri to the Superintendent of Taxes General, Dhubri, bracket General, Dhubri, requiring consideration of the case of the petitioner for appointment against a post reserved for ST bracketed H community candidates subject to de-reservation and after re-advertisement against the post likely to fall vacant as per rules. So, the Superintendent of Taxes on receipt of the said recommendation from the jurisdictional deputy commissioner proceeded wide order dated 31/12/1993 to appoint the petitioner as Chowkidar on ad hoc basis for a period up to 31/1/1994. The petitioner joined his services in pursuance to the said said order dated 31/12/1993. Also, the term of appointment of the petitioner was being extended from time to time. And he continued till his services came to be terminated while issuance of an order dated 30/4/1994. Thereafter, while an order dated 2/5/1994, the petitioner was again appointed on ad hoc basis in the office of the Superintendent of Taxes Dhubri as a Chowkidar for a period up to 31/5/1994 or till the post is filled up by an ST bracketed H candidate. Also, it is projected that the petitioner, however, continued in his services with extensions and while order dated 23/2/2000, the temporary, the engagement of the petitioner against an ad hoc, against a sanctioned vacant post on ad hoc basis came to be regularized with effect from 1/6/1999. Also, the services of the petitioner are now being only regularized since 1/6/1999 and the same not having been given a retrospective effect from the date he had initially joined his services in pursuance to the order dated 31/12/1993, the petitioner has instituted the present writ petition. Mr. S. Islam Lana counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that admittedly the petitioners submits that the petitioner's name having been recommended by the jurisdictional deputy commissioner in pursuance to his recruitment, in pursuance to his selection by the Central Recruitment Committee, Dhubri, the petition was entitled to be so appointed again on a regular basis. However, he was so appointed by the order dated 31/12/1993 on ad hoc basis. Also, Mr. Islam submits that the initial recommendation made in favor of the petitioner by the member secretary, Central Recruitment Board, Dhubri, was wide communication dated 24/12/93 was for his engagement against a regular sanctioned vacant post. However, he submits that subsequently, while an order dated 24/12/1993, 30/12/1993, the Deputy Commissioner Dhubri required the Superintendent of Taxes bracket general bracket over Dhubri to appoint the petitioner in his establishment against a STH vacancy. He submits that there being no STH candidates qualified for the said appointment, the initial appointment of the petitioner ought to have been so made on a regular basis and not on ad hoc basis as was affected by the order dated 31/12/93. Mr. Islam further submits that although the petitioner with effect from the date of his initial engagement, that is on 2/5/2019-94, had continued in his services with artificial breaks, he submits that there is no dispute that during the continuation of the petitioner in his services as on ad hoc basis, any candidate belonging to the STH community came to be recommended for appointment on regular basis in the establishment of the Superintendent of Taxes to be. Accordingly, he submits that while the petitioner's services were regularized wide order dated 23/2/2000, such regularization was limited only with effect from 1/6/1999. However, the same should have been so made effective with effect from 2/5/1994. Accordingly, he submits that the petitioner, having retired from his services on reaching the age of superannuation with effect from 31/6/2020, the pension and pensionary benefits due to the petitioner be directed to be so reckoned by reckoning so computed by reckoning the services rendered by the petitioner with effect from 2/5/1994 and not 1/6/1999. Per contra, Mr. B. Chaudhary, Learned Counsel for the petition for the Learned Standing Council, Finance and Taxation, submits that no select list as prepared by that may have been prepared by the Central Recruitment Committee is available with the respondents, and accordingly, the claim of the petitioner that he was a selected candidate that he was entitled to be appointed against a post reserved for against an unreserved post against an unreserved grateful post cannot be determined at this point of time. It is submitted that the materials brought on record, materials available reveal that the petitioner's initial appointment was on ad hoc basis and was till the post in question was to be filled up by way of recruitment of a candidate belonging to the ST bracketed H category. He further submits that there was no de-reservation of the said post after the petitioner was permitted to continue against the same on ad hoc basis. He submits that the appointment of the petitioner was initial appointment of the petitioner was on ad hoc basis, and the same was renewed from time to was extended from time to time. Accordingly, he submits that the petitioner being found eligible for regularization only with effect from 1/6/1999, while passing of the order dated, while issuance of the order dated 23/2/2000, the said order not being under challenge, the petitioner not being under challenge, and that too within a period proximate to the date of issuance of the said order, it is submitted that the claim of the petitioner for a retrospective regularization of his services would not mandate acceptance by this court. I've heard the learned counsel for the parties and also perused the materials available on record. The facts as noticed herein above are not in dispute. Accordingly, the same is not reiterated. The materials brought on record does not reveal that the ad hoc appointment, that the engagement of the petitioner, while the order dated 31/12/1993, on ad hoc basis as an office chokida in the establishment of the Superintendent of Taxes Dhubri, was so affected, basing on his selection, basing on the merit position obtained by him in the connected selection process. The said order only reveals that the engagement of the petitioner on ad hoc basis was against a vacancy reserved for ST(H) candidate subject to de-reservation of the post. Also, the orders extending the services of the petitioner also reveals that such extension was also being granted against a post reserved for HTH community candidate, and the extensions were also with the stipulation that the same would be till the post is filled up by a STH candidate. Accordingly, it is seen from further from the materials brought on record, it is not revealed that the post STH post, the reserve post for STH community candidate in the grade 4 cadre of the establishment of the Superintendent of Taxes Dhubri was at any point of time de-reserved, which would have permitted the accommodation of a general community candidate against the same. Also, in absence of such materials coming on record, and further it not being established that the petitioner was entitled to be appointed on as against a grade 4 vacant post, basing on the merit position obtained by him in the connected selection process, this court is of the considered view that the initial appointment of the petitioner affected by initial engagement of the petitioner affected by the order dated 31/12/1993 on ad hoc basis would not mandate a reconsideration. Also, accordingly, the petitioner's services were regularized on while order dated 23/2/2000 with effect from 1/6/1999. The petitioner is found to have accepted the said regularization of his services so affected with effect from 1/6/1999, and the grievance raised by him in the matter is found to have been raised after 7 years before the Superintendent of Taxes Dhubri. After having submitted a representation in the matter in the year 2007, the petitioner is found to have thereafter submitted a representation on 31/3/2017, and it is only thereafter that the present petition was instituted after 18 years with effect from the date passing of the order regularizing services. The delay occasioning in the matter has not been explained by the petitioner in the petition. Also, further, the petitioner not being found to have been engaged on regular basis with effect from 31/12/1993, this court is of the considered view that in absence of a challenge to the order of regularization of the petitioner with effect from order dated so and so, order dated 23 to 2000, regularizing the services of the petitioner from with effect from 1/6/1999, comma, the prayer of the petition for having for grant of retrospective effect to such regularization of the services with effect from 2/5/1994 would not mandate an acceptance, and accordingly, the said claim made by the petitioner in the present stands rejected. In view of the above, the present petition is held to be devoid of any merit. However, there would be no order as to.
Publish.
Yes, Mr. Som.
I have challenged, my lord, order of penalty for reduction of basic pay for 2 stage, my lord. Lordship may kindly come to page 17, the so-called notice.
Page?
Page 17, 17. Dated 10/10/2018, my lord. This is the omnibus, my lord, article of charges. But may, my lord, take your lordship to the relevant portion of the.
You had sanctioned 14 loans
Yes, my lord.
of the same nature.
Same
Allegations are of same nature.
Same nature.
That you did not do the pre-sanction verifications and post-sanction also the duties that were there for you to do, you had not done. And what about the other persons who were involved along with the petition? Because this is not an act, he had done it on his own.
No, that act, whether the other people were proceeded against or not, that is not clear in the records because
Okay.
I also have made an inquiry and find anything.
Yes.
And that show cause notice has been issued after a lapse of 5 years. While I have been posted in different branches. My lord, the other persons.
Because
Take the
Mr.
superior
Sharma, the
officer.
problem was all these accounts became NPA.
My lord.
They were or short dying accounts, everything.
My lord.
So naturally, you show me that from your reply, the first point that you have taken, that the allegations are vague and accordingly no proceeding thereon is permissible. Have you taken that?
My lord, page 21 is my reply, my lord. The petitioner was not solely responsible.
That is why otherwise this type of penalties, it's dismissal from service. You have been given only deduction by 2 stages.
That also, my lord, the act of the, my lord, petitioner and whatever may be, during the period, my lord, 1/9/2011, and show cause notice was issued on 10/10/2018. After a lapse of 5 years. My lord, as per my reply, my lord, petitioner not responsible for the allegations level against him, but that may be due to my lord sanctioning authority of the superior officer to him, my lord. And then your lordship may kindly come to the church's page 26. Page 26. Article of charges, first paragraph, my lord. During the tenure of your service as assistant manager at Bank's Lakhimpur branch, on 1/9/2011 to 28/2/2015, you have committed gross irregularities in disposal of the loan and advance as an officer looking after the credit portfolio of the branch. Next line is very important, my lord. You are also equally responsible for any irregularities committed in the disbursement of loans in advance. The detail of the irregularities committed by you are narrated herein below. My lord, you are also equally responsible. My lord, it means and it reveals that there are some other persons, including the superior officers, are also responsible. But no proceeding has been initiated against anyone except me, my lord. This is one of the grounds.
You come
And
to the charge, one charge. Shakur Ali.
my lord,
Read that.
on your recommendation, a loan for purchasing a tractor was sanctioned by the senior manager of the branch in the name of Muhammad Shukur Ali, loan account number so and so on 19/2/2013 for an amount of rupees so and so. The irregularities committed by you as recommended officer are narrated herein below. Margin money rupees so and so was not deposited in the margin deposit account. Processing was done with coverage of 64 bighas of land, whereas no land documents valid listed of the land found with the loan documents. Documents audit was not done. As the officer of the branch looking after the credit portfolio, you did not take post-disbursement monitoring and follow-up measures as required, for which the loan account has turned into NPA, and it is a case of quick mortality as per IR.
We have got it. We have got
My
it.
lord, how can I monitor? I have been transferred and I was in a different branch thereafter.
Hmm.
And then your lordship may kindly see there is no mention in the article of search
Hmm.
that past conduct of the petitioner will be taken into consideration. That was not there nowhere it was there, ma'am.
Hmm.
Page 26 to my lord, page 33, your lordship, nowhere they have mentioned that your past service will be, past record and past service record would be taken into consideration for imposition of penalty or whatever. Then your lordship may kindly say page 34 is the reply to the article of service. We have specifically mentioned in the reply that as per prudence, I think that the regularization is not applicable in my case because I was not the branch head having discretionary power to sanction of loans and advance of the branch, but to carry out the order of my superior for interest of the bank.
Okay. Now, these documents, what are they? They're produced in the inquiry through a witness.
My lord.
Now, the things that you are trying to project now, did you put that to the witnesses appearing? Did you ask the witness that the margin money is not there?
My
How am I responsible for that? The matter has become an NPA or the mortgages as required has not taken. What
Right.
is my role there? What were your questions to the witnesses?
For that, my lord, record is required.
The matter is pending from
Yes, my lord.
20, now
Yes.
after 6 years. What is you should have it.
My lord, I don't have that document, but record is required, my lord, since the
No,
matter is
no,
regarding the departmental proceeding. my lord.
Now,
The
the
proceed-
inquiry of report, what I find
My lord,
is that these materials were brought on record by the inquiry, by the PW, and thereafter you did not cross it. Now, whether in your affidavit, in your representation, you have taken this plea?
in the inquiry report, my lord, your lordship may kindly see.
Come to page 40.
Yes, my lord.
Last paragraph.
Corroboration. For a corroboration FW1 in response to the ME1, it was sustained that on recommendation of Sri Prasanto Kumar Sharma, a loan of rupees so and so was sanctioned by the senior manager of Lakhimpur branch, Mohammad Shukur Ali, for purchasing of a tractor. The processing of the loan proposal was done by Sri Sharma for coverage of 64 bighas of land, whereas land documents avail leased it of the lead measured so and so, land measured so and so only is found with the loan documents. Contention of Sri Sharma in his written submission dated 29/10/2019, as well as during the course of inquiry that stated land was only for the future hypothecation would not be accepted, as there is evidence in support of his argument. Margin money of rupees 41,000 stipulated in the loan sanction letter was not obtained. Then your lordship may kindly see the findings of the inquiry officer. It's very important. Page 48, my lord.
When was the first loan sanctioned? Sanction date of the first loan?
That is
19/2. Mr. Sharma, when were you transferred out of this branch?
2015.
15, 2 years. So you were there at least for around 2, because these were all sanctioned on a particular date. In the month of February, November, within November 2013. So you had time for follow-up action. You were not immediately transferred out. You were there for 2 years, roundabout. So that plea will not work. Yes, what do you want me to show? See?
My lord, from the inquiry report, my
Yes, page.
Page 55.
Final analysis.
My lord. I would like to, my lord, take your lordship to clause C. It is C. It is proved that no documents audit was done as per bank's norm. Agreement of CSO that it is the responsibility of the branch head to ensure proper documents would not be accepted, as it is the jointly responsibility of all the officers involved in the loan sanction as documents of the loan to ensure proper document audit. Then your lordship may skip to the last paragraph. Though Sri Sharma raised above points in his defense, he could not produce any documentary evidence in
No, what
support
is
of his
this points that Mr. Sharma has raised? That is not reflected, not very clear.
Not very clear from the inquiry. However, last line, my lord, from that. However, in reply to the above mentioned points raised by CSO, it is his defense, it may be argued that the safe lending and protection of banks' interests are the topmost priority of the bank officials, and all the officers involving in the lending process are jointly and collectively responsible, and hence Sri Sharma was duly bound to ensure deposit of margin money. And findings of the inquiry report is there. My lord, all the officers involved in the sanctioning process are jointly and collectively responsible. But none of the other persons except the petitioner has serve any show cause notice, no departmental proceeding has been initiated against the other persons.
Where have you stated that? Where is your pleading to that effect?
My lord. My lord, I straightway, my lord, take your lordship to my reply against the affidavit in opposition.
There is no statement in the writ petition, I suppose.
Look,
Okay. Para 14.
para 13 also, my lord.
Hmm.
And para 14, last line is very specific, my lord.
They have not answered that.
Yes,
They have skipped out.
and so far, our service is concerned that, my lord, pleaded case is at page, my lord, 14, paragraph 16.
Where is that order of the disciplinary authority?
59.
Page 59, my lord. Annex 10.
Now, do you have a history of penalties being imposed upon you?
No, my lord.
Then this word and your past records will be of no consequence.
No, my lord, there was an earlier proceeding and penalty was imposed. That
What was the penalty imposed?
That aspect, my lord, I have to look into, my lord. There was an, my lord, inquiry and for the interference of this honorable court, that has been, my lord, set aside and passed earlier.
Yes, Mr. Ganguly. All said and done. He is correct. He did not do his duties properly. But he was only one of the tables through which the proposal passed. Your higher authorities had the duty while sanctioning the proposal to look into whether the margin money has been got, whether the mortgages with regard to the securities, mortgages were taken or not. I'm not exonerating, he is guilty. But if he is guilty and a loss has occasion because the accounts became NPA and that too in a very short period. Now, what proceedings have you instituted against the branch head and the other persons who were involved?
Regarding proceeding against other those officers, I do not have the instruction at this.
Because, see, he cannot be solely held responsible here. And if this is the allegation against him, why a penalty of dismissal or removal not given? Because you earned a substantive loss here. You have not even recovered that money also.
This
So this is
loss
just
amount.
to make a show that we have done something.
No, in page 57, he has not denied that he had not committed the mistakes in question.
Not on that. He is not the sole person.
Yes.
It's not your case also because you did it. That's why the other authorities passed. And your inquiry officer also says that it's a shared responsibility.
Collective responsibility.
So if it is a collective responsibility, whether you have proceeded against them and it was established that it was because of the petitioner's fault that they had to do that.
Lordship. Two aspects of the matter. One, the record or the evidence before the inquiry officer was only regarding the petition. There was nothing led by either side that A, B, C also was involved.
No,
So on that
his
ground,
conclusions say that it is not something only solely for the
yes,
petition.
because he was the second man in the branch. Now these are more or less rural branches wherein he was the assistant manager. He was effectively the second man. So, my lord, ordinarily, the branch head should also be held responsible. In this particular proceeding, I do not have the instruction whether branch head or anybody else was proceeded
In
against.
some other proceeding.
In some other proceeding, because that is nowhere in the record. And in fact, my lord, the
Affidavits also done.
affidavit in opposition was filed by my.
Because why I'm saying so, the petitioner in paragraph
Yes,
14, in page
Yes.
13, had taken a categorical plea.
and that has not been answered.
That is not been answered.
Lord. My predecessor, my lord, my
Yes, 66 to 71 at the
my friend
affidavit
had
in
filed the
opposition.
affidavit because he is now no more. So, my lord, that aspect he has not gone into. We have not.
You
go-
just have your instructions on
Lord.
that.
But as far as the other point is concerned, my lord, on that, my lord, that past record, because nowhere the past record has been referred to, and lordship knows. my
Yeah,
lord,
use
these
of
are
those words will not cause any prejudice.
adding weight, my lord,
We're adding weight.
adding weight. On that aspect, my lord, what I can do is that perhaps I can also bring on record the original departmental inquiry report, along with the instruction whether anyone else was proceeded against or not.
But the learned counsel heard Mr. D.K. Sharma, learned counsel for the petitioner. So heard Mr. A. Ganguly, learned counsel appearing for the respondent number 4 and 5. Hearing remains inconclusive. Mr. Ganguly submits that he would produce on the next date of listing the records of the departmental being held against the in original. Mr. Ganguly shall also apprise this court as to basing on the same allegations as held against the proceedings were also instituted against the branch head at the branch head against the officer who was the branch head of the branch at the relevant point of time. So, register to list this matter. How long will it take to get it?
Lordship will have it in the third week of May, perhaps.
Too much, I'll forget. We'll have it on
Then
15. Onnotai kasane matter.
15th is it?
Fantastic.
15th.
15.
My
15.
lordship may kindly say branch head or any other
A branch head or any other
office.
officer. Me.
Obliged.
Go further here. And you retired immediately after that. After
Yes,
this
my lord.
penalty was given, you
Penalty
retired.
was imposed in the December 2019. I have retired from service on January 20.
Maybe that is why they gave you a lenient penalty.
That
Maybe.
may be.
No, my lord, hurriedly they have imposed the penalty.
Because
Suppose he is retiring.
person is no more.
Person is no more, my lord. In fact, he filed the writ petition earlier, then my lord,
That was withdrawn. Any procedural irregularity?
Yes, ma'am. Firstly, my lord, the witnesses whose names were listed in the my lord charge sheet, they were not examined. But some other persons have been, my lord, examined, and that too without notice. Listed witnesses not examined, unlisted witnesses examined without notice. So this has caused prejudice because, my lord, the petitioner was taken by surprise. That is also, my lord, violation of the principles of natural justice. The second point is that, my lord, the inquiry officer gave his findings all on the, my lord, articles of services as proved. And, my lord, the petitioner also filed his, my lord, response to the inquiry officer's report. But the disciplinary authority has not, my lord, given any reasons, my lord, merely without discussing anything, my lord, he has.
Has he concurred with the inquiry officer's finding?
No, my lord. He has agreed to all the, my lord, concurred.
That's it. He agreed.
Concurred.
What further
My
reasons
lord,
has
even if he concurs, my lord, the fact that, my lord, he has applied his mind, that has to be reflected, my lord. That has been, as your lordship will know, my lord, in ECI.
Now, these are the 2 points.
These are the 2 points, and the appellate authority also has also, my lord, done this.
That
Now, on that, my lord, I'll I'd like to take your lordship to one paragraph of the ECIL judgment, my lord, where it is said that the disciplinary authority did not give a judgment. But then, my lord, it has to be reflected that he has applied his mind on the charges.
We'll go to that.
These are the, my lord, two grounds.
Two
on
grounds.
which-
Let us have that listed witness thing cleared up. Where did you take a plea with regard to?
I have taken that, my lord. If this listed witnesses will not examine pleading to kun paragraph process. Paragraph 23, my lord, at page 21. That the signatory authorities of the documents based on which the CSO was held guilty of the charges leveled against him was never examined during the proceeding. Thus, the very authenticity of the basis of the charges remain unproved, and as such, the order dated 26/9/2016 passed by the respondent more based on such an inquiry is liable to be set aside as squashed. Moreover, the board of directors has rejected the petitioner's father's prayer to allow him to submit his defense against the charges, hence the petition praying for insurance. So, my lord, this ground was taken.
Okay.
Now, paragraph 24, my lord, we have also taken the ground that, my lord,
Documents.
my lord, cross-examination.
So there is another point.
Right.
Vital documents. Copies not. Now, Mr. Chaudhary, you may have given a written brief before the inquiry officer.
Yes.
Have you taken these points there?
Before the written, my lord, in fact, the written brief, your lordship will find
The
that page
written brief
69.
that is of the, what do you call that, presenting officers. That is of the presenting officer.
No, my lord, I have not annexed that. I have not annexed that. These are the basic points, my lord.
Now, how do you establish this listed witness thing? What are the materials to show that you were
My lord,
prejudice was caused?
Yes, my lord. If your lordship comes to the charge sheet, your lordship will find, my lord, page 60 is the charge sheet. And the listed
68.
witnesses, your lordship will find at page 68.
Okay.
My lord, three persons have been named. Debo Prasad Kolita, senior manager. Then Naresh Chandra Roy, senior manager. Then Subir Pal, assistant manager. So none of these persons have been examined. Instead, my lord, if you're,
One Bhaskar Jyoti Tamuli
my lord,
had come.
my lord.
So how is a prejudice caused to you because of that?
Firstly, my lord,
Now, where have you taken that plea? That he was called because he is not a named witness? He cannot.
my lord, the plea that I have just read, that is
That paragraph, fine, we got it. That is Mr. Chaudhary's paragraph. Where is the prejudice caused to the petitioner's husband during the inquiry? Where is his plea? That say this cannot be done.
that, of course, my lord,
That is something for you to object. If you have accepted that, nothing, they proceed with the matter. You have not raised an objection. There.
My lord, this is a, my lord, subtle proposition of law.
Any decision which says that a witness not named, normally it has to be brought after notice.
Yes.
But if you have not taken a objection to that, but you again crossed him, you peacefully went through the proceedings, no prejudice is caused to you. How do you, this court has to look into the matter.
That, my lord, against the inquiry officer's report, my lord,
Hmm.
the petitioner filed a, my lord, response. In
Therein
fact,
also you have taken.
No, what happened, my lord, this brief has come from other chamber, that has also not been annexed, my lord. But that will be part of the record.
Mr. You have the original.
I have the records, Your
Give me. Take out the part with wherein the cross exam, everything is there.
Yes,
The depositions of the witnesses are evidences are here.
yes. Your Lordship will first come to page 4 of that.
We should have colleague.
The page will start with proceeding of the departmental inquiry.
Mr. Chaudhary, please give me 2 minutes. You just have your seat.
Page 4. The page starts with proceeding.
Finding.
Where is his cross by the petitioner?
Cross, he was put a question whether he wants to cross-examine, but he has
Where do I
denied
get
that.
it?
And page 22 in regard to charge number 1. Third para, now the PO.
Then
Then page 23, last para. Presentation against has been complete. Then page 24, first line, the EO asks the CSO whether he will make cross-examination. In reply, the CSO said in negative. Then page 30, towards the middle, in regard to charge number 3, the CSO replied that he will not make any cross-examination of documents, exhibits presented against documents. Yes, that one. Then page 36. second line. Whether he will make any cross-examination of documents. He replied no. Then page 38. The last line, your lordship will find, page 38. CSO said that he will not ask for cross-examination of the documents against charge number 6. Then next page, last line, page 39. Whether he will make any cross-examination. In reply, he said in negative. Then next page 40. Towards the middle. Now PO declared that the presentation of documents against charge number 7 is complete. The EO asked CSO whether he will make any cross-examination. He replied in negative. Then page 42, last line.
42,
Last line.
43, last, then 11,
then 43 last, then
45.
yes, then 45. Towards the middle. There's nothing to cross-examine against the goods produced against charge number 5. And thereafter, page 46, he was advised to file his argument within 15 days of the receipt of the PO's brief.
Yes. So Chaudhary, with regard to the documents, you had given a certificate that you are satisfactorily examined all the documents. That is DE1, the first day of the inquiry was taken, because second day of the inquiry it was examined. I'll hand over this to you. You better go. Shama, you also go through this. And with regard to the inquiry witness deposing in the inquiry, the witness, each charge, it was taken up separately. And every time you were given an opportunity to cross-examine. Either you objected to that examination of a witness who is not listed, nor you cross-examine that witness. So both the points gone. Now the only point left is DA. Subject, if you can show me some decisions on this. I think you will have to go through this once. Give him a copy. Mr. Sharma, give me some.
I'll give it.
All these copies are not there because the person died, my lord, all the documents could not be.
But Mr. M.K. Chaudhary, assisted by Mr. M. Sharma for the Mr. S. We're hearing for the respondent bank. During Mr. Chaudhary had made his submissions. So during the Mr. S. Dr. Learned, still appearing for the respondent bank, has produced a Xerox copy of the proceedings of the departmental inquiry instituted against the petitioner hearing. Also, considering the nature of the challenge made in the present petition, this court is of the view that before proceeding with the further hearing in the matter, opportunity is to be granted to the counsel for the petitioner to peruse the proceedings of the departmental inquiry as furnished by Mr. S. Doctor. Mr. S. Doctor undertakes that a copy of the same would also be furnished to the, you can give this, would be furnished to the learned counsel for the petitioner. Mr. M. Sharma shall receive a copy of the same from the learned counsel for the respondent. The learned counsel for the petitioners are at liberty to make further submissions in the matter after perusal of the said proceedings. So, register to list this matter again on when
Has your lordship, please.
15. You have a copy, you'll give it or should I give?
I'll Xerox and I'll give.
A copy of the proceedings as of the department inquiry as produced by Mr. S. Dr. Learning Counsel for the response is kept on record and marked as X.
Alia, please.
Obliged.
May I please, your lordship? My lord, this is a matter relates to, my lord, the
Where is
record
Mr. Handick?
of Mal. My lord, this is a matter, my lord, wherein an advertisement had been floated for the, my lord, training purpose for the candidate, my lord, who were eligible and qualified in terms of a particular advertisement, my lord. This recorder certificate class course training, my lord, generally we term this as a mandal, my lord. My lordship knows, my lord. So, my lord, responding to the advertisement, my lord, we did apply, my lord, and accordingly, if I beg to draw my lordship's kind attention, my lord, to page 34, annexure 2, my lord. My lord, if we go from the top to bottom of the advertisement, my lord, there is no provision had been earmarked that there should be any reservation criteria is required to be followed. Now, my lord, and when the selection process is almost over, my lord, then when the final select list was required to be prepared, then only, my lord, the criteria of reservation had been put in the merit list, and by virtue of that, my lord, we being the general and open category candidate, my lord, we had been ousted on merit, my lord. So therefore, my lord, our case is on very limited condition, my lord, that the rule and the, my lord, condition which had been fixed in the advertisement had been subsequently, my lord, has been added the law of reservation. Now, my lord, admittedly, this is not a recruitment in any government or public employment. This is only for, my lord, sponsoring candidate for the purpose of training. And for that, my lord, this Assam, my lord, the Scheduled Caste and Scheduled Tribes of Reservation of Vacancies Act, my lord, from my limited understanding, my lord, may not be applicable. My lord, a similar case, my lord, came into consideration before this honorable court, my lord, by a respected coordinate bench has already decided the issue, my lord. If my lord allows me, my lord, I can place that order also, my lord. If my lord may be pleased to take up the advertisement, which I have just,
Sir,
my lord.
We'll have it, if any other not inquiry, we'll take it up at 2.
My lord, I have a partner hearing going on, my lord, regarding eviction matters, my lord, those forest cases fixed at 2 p.m.
Where?
My lord, in court number 10, my lord. So, my lord, may I, my lord, can be taken up on Thursday, my lord. Some urgency is on our part.
And as per my lord, then my instruction, my lord, then new rules has been come.
Yes.
The 92 is gone,
No, first let us hear
lordship.
as to his thing that if we hold that he is not entitled, what has happened was correct,
Lordship.
then there cannot be a direction for his RCC training because
Now, my lord,
that thing has gone.
lordship, my lord,
That
then
thing has gone. But if we find that he was discriminated against,
my lord, that is.
because there
Now,
are
even
two
then, my lord,
decisions,
that
one of the coordinate bench, another of the division bench, that Mr. Mia will be relying on.
my lord, that RCC training, my lord, after the new rules, lordship, my lord, that RCC training, my lord, that pre qualification for the, my lord, that
That is gone.
recruitment, that is gone. When new rules come, my lord, this rule is, my lord, forward up. First, they have to select it, got the appointment, then, my lord, they will go for the RCC.
But the Learned Counsel for the parties at some length. Registered to list this matter again on Thursday. By slip koi diva.
Obliged, deeply obliged.
May I please, your lordship, my lord, I have a small prayer, my lord.
item 16, my lord. I've just filed my power, my lord, today. So,
Have you taken the consent of the other side?
yes, yes. Only thing that at 2 I have to attend a janaza. That is the reason.
On the prayer of Mr. J. Abedin, learned counsel,
For
appearing for the respond number
8.
8, the matter be fixed again on Tuesday next.
My lord, on 7th, possible, my lord.
7, 7,
Seven.
5,
Thursday. Deeply obliged.
I'm told that Mr. Dixit is unwell today. Madam.
It is a prayer, submission is, a prayer is made on behalf of Mr. D. Gugoi, learned counsel, for the petition on the ground that, for an adjournment in the matter on the ground that he is indisposed. Prayer accepted. Prayer is not objected to by Mr. M.R. Adhikari, learned CGC, appearing for the respondent. Accordingly, registered to list those matters again.
Sorry, 45.
Well,
Hello, same Dixie.
Same. Miss A. Gayana, right?
Must have like.
Same.
95.
10.
Yes, Mr.
Lordship must control the facts of the case, Lordship.
Hmm.
He was initially appointed as MR worker in the year 1976.
His name was dropped, and thereafter that position was recognized. But unfortunately, that process could not be taken to its logical conclusion. Whereas persons junior to him at that point of time were all regularized.
2005. The only issue is, Lordship, whether the person whose services were not regularized or who were dropped, Lordship, in the year
And
2005.
your affidavit that is here,
Lordship.
it does not take into consideration these submissions. It says, we will regularize moment the approval from the government is received.
Yes. Why it was stated, Lordship? Because after 2005, Lordship, in 2006, Lordship, another notification was issued by the state government, finance department.
2012 notification is also there that no further regularization.
Subsequent.
But still you have filed this affidavit.
No. Yes, it is there, Lordship. Affidavit is there, Lordship, but Lordship will also take note of the legal position, Lordship.
The legal position, how can I go beyond when you want to regularize the person?
Lordship.
And there is no other affidavit filed here. This is the only affidavit. And that supports the petitioner. So in the
Yes.
facts of this case, we are saying, we'll say it's not a precedent, that's all.
No. In this case, Lordship, this was an affidavit filed by the executive engineer.
Whoever it is, you have
Probably-
not disowned this affidavit.
No, definitely not, Lordship. But Lordship will also take note of the legal position, Lordship, and recent judgment, Lordship. My submission will be, Lordship, in 2006 itself, Lordship, Finance Department issued a notification instructing all the departments to forward the names of the, the master and works as employees, Lordship, whose names were dropped in the process of 2005, Lordship. Accordingly, names were sent. But Lordship, in the meantime, the Umadevi judgment came, Lordship. And thereafter, Lordship, Jiten Kalita was there. State government filed an application before the division bench, Lordship, Gauhati High Court, praying for grant of leave, Lordship, to the state government to continue with the process of regularization. That was rejected by the division bench, Lordship. And the process got stalled there. Thereafter, Lordship, we first issued the notification of 2012. Lordship is aware about that notification. That was initially set aside by the learned single judge. It was reversed by the division bench. In 2013, Lordship, there is another notification. 3 conditions of Umadevi, Lordship, incorporated there. Those who fulfills those conditions, Lordship, their services will be regularized. Otherwise not, Lordship. Probably in this case, Lordship, his case for regularization was forwarded in the year 2007.
No, it was in 2005, it was dropped.
Yes, 2005 it was dropped, but pursuant to 2006 notification, Lordship, his name was forwarded in the year 2007. Lordship, may kindly see paragraph 6 of the affidavit.
Paragraph 6, Lordship may kindly come to the fourth line. The proposal for regularization has been sent to the Chief Engineer PW Roads Assam, Sanmari, Guwahati by the Executive Engineer Karimganj NEC Division by letter number so and so dated 26/2007. So this was prior to 2012, but it was pursuant to the notification of Finance Department 2006. Probably they are not aware about the subsequent developments, Lordship. That is why this affidavit was filed. But Lordship will.
But this affidavit has been filed through a counsel who is aware of these things. He is a counsel appearing in the High Court. He is a counsel appearing in the High Court.
Yes, it was filed in the year 2017, Lordship. That was prior to Upendas, Lordship. Prior to Upendas.
The person who has filed the thick of the things, but that instruction that has come,
Lordship,
is in a different.
Now, in that situation, Lordship may either allow me to file a fresh affidavit, Lordship, bringing into record all the subsequent developments. That is one. Or Lordship will take note of the legal position that has been settled either by the Supreme Court.
Where is my orders? I passed some orders.
Lordship, that order I am also looking for, Lordship. On last date, Lordship, I furnished one order, I think. Lordship, another order was there, Lordship. This is by a coordinate bench, Lordship.
Similar fact situation.
Similar facts, Lordship. They are also claim retrospective regularization pursuant to, from 2005, Lordship.
Amal Kanta, Justice Borua's judgment.
Yes, Lordship. This judgment has not been interfered by the division bench, Lordship. Lordship, here the first ground was taken that that he was recruited through a, proper recruitment process, Lordship. That is not claimed, Lordship. So illegal appointment.
The Dharam Singh's judgment has been.
That has also been deferred, Lord.
Distinguished.
Distinguished, Lordship. So that is one, Lordship. Second, Lordship, that retrospective regularization. He is claiming regularization from 2005.
2002. You have retired when, Mr.
Lordship, retired on 01/2/2017, Lordship. 1st February 2017, Lordship. No, letter is there. I have annexed the same. That letter I filed a affidavit, so there is.
Why did you wait for such a long time?
67 page, Lordship.
It's 67. There is a letter. 31/1/2007. 31/1/2007.
The government holiday and.
Center. Mr. Majumdar.
Lordship, please.
All said and done.
Lordship.
Is correct. Also passed an order in.
One paragraph, Lordship. He has placed one judgment regarding discrimination, Lordship. Lordship.
Just now.
There is another case wherein discrimination has.
Just what? 4 lines of Umadevi judgment, Lordship. Paragraph 53, last 4 lines only, Lordship. That discrimination has been done away with, Lordship. Once therein, Lordship, Supreme Court said, Lordship, those whose services has been regularized, Lordship. But their services will not be opened up now. But in future, Lordship, any regularization.
This is a decision after Umadevi.
Yes, Lordship.
In this judgment, Lordship, probably it is 2023 live law, Lordship. Lordship, this is a judgment, Lordship, regularization earlier regularizations were also subsequent to Umadevi judgment, Lordship. But here I am submitting, Lordship, Umadevi 2006, earlier regularization was 2005. So that is why those regularizations prior to 2005-6, Lordship.
Why was your case not considered in the first round?
Lordship, they have considered on pick and choose basis, Lordship. Why now only grievance is that the juniors were promoted, I have implemented them as a party. And since the government has filed, they admitted my position, Lordship, that my case will be considered. Lordship, being a poor masteral worker, Lordship, he is now at 2017 to till date, not a single penny, Lordship. I respectfully submit, Lordship, my case is squarely covered by this 2023 live law judgment, Lordship. So my learned friend is saying, it is a single case, Lordship, and what they may raise, Lordship, regarding floodgate, Lordship, that I already referred one judgment to before your Lordship. So kindly consider that aspect, Lordship. A man is working from since 1976, Lordship, and he is deprived. Others are getting benefit, everything they are getting, and he is on the street, Lordship. So I leave it to your Lordship, whatever to Lordship.
So
because he is now aged now as a bedridden person, Lordship. He has just 2 days morning, he has called me, sir, anything can be happen. So, Lordship, I leave it to your Lordship.
Lordship, another judgment is there, Lordship, Puransan Pandey, Lordship. Therein also, Lordship, discrimination was the ground for, Lordship, granting regularization. That was subsequently, declared obiter dicta by the official liquidator case, Lordship. So it was because it was in violation of Umadevi law.
Okay.
This judgment will still hold in the field, Lordship, which I referred, Lordship. I leave it to your Lordship.
But Mr. K. Majumdar, Learned Counsel for the petition. Also heard Mr. P. Nayak, Learned Additional Advocate General, appearing for all the response, appearing for all the response. Oh, you are appearing for all?
Except 8, Lordship.
8 is a private respondent.
For respond number 1 to 7, none has entered appearance for one number 8. Hearing concluded. Registry to list this matter again on 13/5/2020 for delivery of the
March.
Let me give it a thought.
Lordship, entire things, Lordship, I have collected all the judgment, what my learned friend, Lordship, there is something, Lordship.
Mr. Majumdar, there is a doubt in my mind. That's why I have kept it reserved.
Lordship,
I have passed the order today.
Lordship, I leave it to your Lordship, because
I cannot ignore one thing. I cannot ignore the decision of the binding on me.
That is
the way the matter reached the division bench in Upendas, I know that.
Lordship,
It is persons similarly situated like you.
after Upendar's Lordship, this Honorable Appeals Court passed the
The
judgment.
division bench, it's near to me. So
Lordship,
it's more
Pending.
and
it's
this,
like the sun is there, but the moon is more nearer.
Lordship,
the moon is
with
more
due respect,
influential.
all respect, Lordship, I am submitting, Lordship.
And
Lordship,
Mr. Majumdar, there
Lordship.
is a decision of decision of the Supreme Court. It is called just the obstinacy of judges ignoring the binding precedent of a division bench of the same court,
Lordship.
and then going and trying to overrule that thing by citing judgments of the Supreme Court. That judgment has been recently again. It was a 19 Yusuf. That was gone into oblivion. Recently, Supreme Court has again brought that into operation. You have that judgment, Yusuf.
Lordship, I'll find it out.
Just give it to me.
I'm aware about that judgment, Lordship. I'll find it out.
So while sitting here, I'll have to be.
Lordship, that discriminatory part, Lordship.
See,
I
am
agree
with
to
you.
all this, Lordship.
I am with you. If I can do it, I'll do it. Don't
Lordship,
worry. But thing is, I'll also have to keep the
Lordship, with all respect, Lordship, I cannot, Lordship, but I am submitting my
Normally, my normal this thing, I would not have kept it. I would have.
Lordship,
That's
I
my order.
agree on that.
But I have a. Let me just give it a thought. Let me give it a thought.
Lordship.
You give me that, Yusuf.
Lordship. Lordship, if, Lordship has not reserved for judgment.
No. It's for delivery of orders.
Then on next date, Lordship, I will place the entire affidavit that I have recently filed before the division bench. So I have brought into record the entire facts.
We don't want it. We know that.
Yes.
You'll only bring in how you went to, how Upendas was filed. That's all. The
Yes.
background leading to Upendas, nothing more, nothing less.
No, Lordship, why, in spite of our willingness to continue with the regularization,
Okay, fine.
process, we could not.
You have gone up. There was a 2012 notification that was put to challenge here. The single judge negated that challenge. Against that, an appeal was filed.
Lordship.
The High Court from para 1 to para 21 said everything against, held everything against the petition appellants. But 22 noticing the undertaking or the
Yes.
whatever the relaxation given by the state, para 22 was recorded. Again in para 23 it was said no further regularization. That is what is binding my hands.
No further regularization for the purpose of consequential benefits like fraction.
Anything. That is the only thing that is keeping my hands tied. Let me see if I can open it. If I can't open
Lordship,
it, I'll have to open.
That delay was not on my part, Lordship. The petitioners.
We will not hold your delayed approach to this court against you. That much assured.
The judgment, Lordship, I have furnished by my Lord Justice D. Bora, Lordship. Therein the ground also taken by the court. That 2012 notification was not challenged by you.
No, 2012 he challenges, challenges.
At
That thing
point
has
of time-
attained finality now.
Yes, that has attained finality.
And that too, 2012 judgment will not come on my way, Lordship. Because
Notification.
my case is prior to that, Lordship. What my Lordship, the earlier, this honorable.
We'll see, Mr. Modi.
4822,
Obliged.
Lordship, observed that. And
Wait, yeah.
much obliged, Lordship.
Yeah. Oh, delivery of order. Yes, Mr.
The results are in sealed cover, my lord.
Forget the results.
My lord,
What to do? Can something be done?
Lord, as per that Sri Krishnan judgment, since they are allowed to
Participate. We'll allow them.
but
You declare the results. The results are there. Have they cleared?
my lord, it's in sealed cover.
You open up.
My lord, it will be better if your lordship.
Okay. Yeah. Sir, you can have your seat. What does that mean that no record found in the tabulation register?
My lord, record should be there, my lord.
Why have you, who is this controller examination writing all this?
He has already expired, my lord, that
Oh, still, but
is a
thing is that this is an old one.
old one. On 17 February 2021, my lord.
Okay, this was with you,
my lord.
but the results are not here. And you also in your affidavit say that they have participated in the examination in BA Part 3 examination in 2013.
2013.
13.
My lord, the respondent number 4, the principal of Golpara College, he has scrutinized the entire, my lord, things, my lord, and allowed them to appear.
No, we get it. We get it. They have appeared.
My lord.
So they'll have some marks. They have scored some marks in the exam. What is those marks? And that is what exactly was directed to be produced before this court. Have you seen that?
Mark sheet not generated.
Not generated.
But it must be there, my lord. If they appeared, my lord, then.
No, if they have not appeared, fine. No issue. But the stand taken by all is that they have appeared. So if we pass an order without knowing that, it will be a futile order in futility.
My lord, my affidavit is regarding allowing by the respondent number 4 to appear. But whether they have in fact appeared is not clear from the paragraph number 12 and 10.
So we had asked you whether they have passed the examination. That much only.
My lord.
Can you get that instruction, Mr.
My lord.
Khan?
My lord.
Because this does not reveal anything. Those are documents which are already available.
My lord. After verification of all the original tabulation register, no record were found. I'll have to take instruction.
But Mr. N.C. Das, learned counsel for the petitioner at some length. Mr. P.J. Fukan, learned standing counsel. Gauhati University, in terms of the earlier orders passed by this court requiring the production of the mark sheets of the petitioners in a sealed envelope, has placed before this court a sealed envelope. So this court, on opening the said sealed envelope, does not find the mark sheets of the petitioners to be included therein. However, there is a tabulation sheet, and therefrom it is revealed that the result of the petitioner number 1 was withheld, whereas in respect of the other petitioners, an endorsement has been made to the effect that the marks were not found in the tabulation register.
Tabulation
register. Also, Mr. Fukan submits that he would clarify, he would receive clarifications in the matter from the authorities of the Gauhati University and apprise the scope of the position. Also, Mr. Pray accepted Mr. Fukan to apprise this court or to place before this court the mark sheets of the petitioners of their part 3 of their BA examination and or the marks and or table and or a list wherein the marks scored by the petitioners in various subjects are so recorded under the signature of the controller of examinations, Gauhati University.
Yeah.
When?
On 15th minute.
registry to list this matter again on 15/5/2026 for further hearing. The seal envelope, after opening, the contents thereof has been returned to Mr. P.J. Fukan, Learned Standing Counsel, Gauhati University, in the court today.
Most of
Yes. Just check up, Mr. Boys, if they are passed, we will proceed. That's all.
Milord.
They are not clear, can't help it.
Your Lordship, I'd like to make my final submission today, and then it's up to Your Lordship. So, Your Lordship, the petitioners repeated service extensions and continued service beyond the contractual period, and the subsequent disqualification, particularly after about 14 years of uninterrupted service, had given rise to a legitimate expectation of permanency, Your Lordship. And while pursuant to Your Lordship directions in the last date regarding certain case laws, I have reviewed certain cases, Your Lordship, and Your Lordship was right, Your Lordship. Most of the cases have deemed that the regularization cannot be possible, Your Lordship. However, while going through it, I have come across a case law, Your Lordship, of the Himachal Pradesh High Court, Division Bench of the Himachal Pradesh High Court, wherein it was ruled that the long-serving contractual computer operators under the so-and-so initiative must be regularized, holding that repeated service extensions creates a legitimate expectation of permanency on part of the petitioner.
But the problem here is that this is not a permanent estate, a temporary estate. There can be no regularization.
Your Lordship, if I, with your due permission, may read a little from the case that I have made. Lordship may kindly refer to page 37 of the judgment, Your Lordship, where this doctrine of legitimate expectation was discussed, Your Lordship.
Okay, Mr. Bora, why? Why was she discharged?
Look, first of all, my lord, the discharge is after the period expiry.
We got it, but what is the reason? Every contract you renew after the period is over. Now, in case of the petitioner, she was continuing,
Right.
She, Your Lordship.
She was continuing,
She was
because
continuing
there
for a
are
long time.
33,000 persons in the SSN, or SSI is just a mission.
Okay, fine, but what is the reason? Misconduct, non-performance, what is the reason?
Let's see. What will turn to the MP order, page number 18. The agreement of Mr. So-and-so, draftsman, civil works.
I only want to know why it was, because this is not you have not taken a plea that you don't want the person to man that work.
It is not, that particular job is not required now.
Where is that?
Hello. Lordship takes.
Where is your stipulation to that effect?
If Lordship turns to page number
Of your affidavit?
affidavit, my lord. Page number 23. Second paragraph, last portion, my lord. The release order dated 1/4/2020 clearly indicates that third service will no longer be required as SSA with effect from 2/4/2025.
Not required. She is not required is one thing.
No, let me finish it, my lord. Therefore, it is absence of the contract, the petitioner is not entitled to service. As regard to the contention of the replacement of the petitioner, of which
I'm sorry, this cannot be the law.
My lord, let me finish it, my lord. That no other person will be appointed on that particular post, my lord.
Well, you have not said that. You have said the other way around, that she cannot make a claim to that effect.
Page number, paragraph number 8, my lord. Further, the answer and deponent beg to state that as now that the respondent number 2 is not required of the documents to continue in the service and it petition after the expiry of the contract, my lord.
As of now.
As of now. At least is not required, my lord.
Where is your
services contract has come in, my lord. There is no requirement.
So para 8 is as per records. Get me the records wherein this satisfaction was arrived at.
No, that can be done.
Heard Mr.
I.S. Mazharvi.
I.S. Mazharvi, Learned Counsel for the petitioner. Also heard Mr. S. Bora, Learned Counsel, appearing for the Learned Standing Counsel, SSA. Mr. Mazharvi, Learned Mr. Mazharvi, Learned Counsel for the petitioner has submitted that while the petitioner was by the impugn order dated 01/04/2025 released from her services on the ground that the contract that the agreement entered with her was not extended after 31/7/2024. He submits that no reason has been assigned for such release of the petitioner from her contractual service, which is projected to be continuing with effect from when were you first engaged?
Lordship, 2011, but the first salary was received.
2011. From 2011. Also. Mr. Bora, in response to the said submission of the Learned Counsel for the petitioner, as by referring to para 8 of the affidavit filed by the SSA authorities, has submitted that as of now, there is no requirement for having the services of any draftsman, and accordingly in the organization, and accordingly the service of the petitioner after the expiration of the contract was not extended. Mr. Bora submits that he would justify the said contention made in the affidavit by furnishing the original records wherein the said decision of the authorities is available. So, in view of the above, the registry to list this matter again on 19/5/2026 for further hearing.
Much obliged, Your Lordship.
Mr. Madhav, I'm just trying. Let us see something comes up, but don't have much hope. We can only try. Let's see. Mr. Chaudhary, what are you waiting for?
Two that is fixed again. That Homeguard madam.
Oh, who is there for you, for opposing you? You are tired for last 2-3 days. Now I think you should take some rest.
Till tomorrow.
Oh, you have to take rest. Why are you troubling him? When you want it. We'll take it up for final consideration.
Yes, ma'am.
When?
After Eid, my lord, after that, May.
Tell me, give me a date.
After first week of May, any day.
Eid?
Eid is 27. May.
May 27.
Oh, so, yes, my, yes,
That's why.
yes, my, sorry. Don't first week.
He is already exhausted. You should give him some rest. 2 days. Can we have it on 19th or 21?
19th of
May?
Yeah.
It would be on 26th, 7th.
Yes, yes, 19,
19 fine. 21.
21.
As agreed to by the Learned Council for
No,
deputies,
item-
raised it to list this matter again. Matters again, huh? 32 to
35.
36
36. Going on.
on 21 5/20/26 for admission hearing.
Interim.
Interim orders passed earlier to continue till the next date.
Obliged.
Now he should take rest. No, he should not do this.
I'm going, my lord.
The exhaustion is very large.
Tonkeshwar Nath, my lord. Hearing report, my lord, page 54. Item number 18, my lord. B.Ed. Dot prosecution.
Okay, where did you, what is your, the course that you undertook without permission?
Or the B.Ed degree, my lord.
B.Ed.
B.Ed, my lord.
From where did you do that? Where is your B.Ed degree?
My lord, page 38, my lord. Thirty-eight and 39, my lord.
Okay. Then what happened?
Then, my lord, the respondent number 5, pursuant to the retirement superannuation of the earlier principal, my lord, was made the principal, which I agreed thereto, my lord. I prefer two representations at page 41 and at page 43.
Page 40 is the order.
Page 40 is the order. Page 41 and page 43 were separate representations, which I preferred, my lord. There were no responses to those. Then I was constrained to prefer another representation at page 46 in the year 2025. Pursuant to that, my lord, I was given a letter for hearing my case vis-a-vis the case of the respondent number 5, which is at page 49. Now, there was no response from the authorities, pursuant to which, my lord, I preferred the item number 19. Then, my lord, when that item number 19 was pending before the Honorable Court on 12/12/2025, my lord, the department comes back with a hearing report, which is at page 54. And in page 54, my lord, they've agreed to all the contentions which I have raised. However, they've rejected my claim, stating that there is a matter under appeal before the Honorable Division Bench.
There is a appeal there, no?
No, my lord, that appeal pertains to a matter where the learned single judge had talked about whether disciplinary actions can be initiated against employees who had undertaken B.Ed without permission. Here, the subject matter is completely different, my lord. That, my lord, I have annexed that learned single judge's order, which is at page 56. So, assuming that is under appeal and the Honorable Division Bench also finds an conclusive determination to that appeal, my lord, that will not touch this case. That is,
there is no proceeding initiated against you.
No, nothing. They've agreed to it, my lord. At page 54, they've agreed that I am the senior most. The Honorable High Court on earlier occasions had addressed the issue. However, there's just two lines that they've added, my lord, that rejects my case. 2 lines. Moreover, a similar judgment was made by the Honorable High Court in WPC so-and-so, dated so-and-so, which is further appealed by the government for modification, alteration, cancellation. As the matter is now sub judice, any decision on the basis of the above order could not be made at this point in time.
That is joint on you.
That is joint on you. And that aspect is completely different. And as far as I'm aware, my lord, from my last perusal of the Gauhati High Court website, that appeal is pending at the stage of condonation of delay, my lord.
Appeal preferred by the state.
State. That, my lord, I have annexed the screenshot of it, my lord. The screenshot is at page 81. The time has passed since then, my lord, but page 81.
I'm trying to make out what is this. Okay, now I got it.
That is my case, my lord. Your lordship had rendered categorical judgments, my lord. Tonkeshwar Nath, Mosumi Sohoria, my lord, Dayananda Bhuya, and Madhav Chandra Kulita, where we happen to be on the other side. And that matter has been laid to rest, my lord.
And what about the service of notice upon the
My
respondent?
lord, it has been completed in both the cases, my lord, 18 and 19, and she has not entered appearance in item number 19 and item number 18, my lord. That your lordship will kindly find at page 50. In item number 90, my lord, I have annexed those orders, my lord, page 50.
Item number 9.
Item number 18, I apologize. Item number 80, item number 18, page 50. Page 50, my lord. Page 50.
Okay, what about dear?
Here also, my lord, the last office note, my lord, it's indicated, my lord, that service has been effected on respondent number 5, and she has not entered appearance, even in item number 19 as well as in 18, my lord.
No, has the service been held to be complete?
Yes, my lord. Yes, my lord. In this matter, yes, my lord. That was a submission I made, my lord, before this court on an earlier occasion. My lord, Justice Silo's order, my lord.
Yes.
Lordship, I did not have the up-to-date instructions, but with the hearing report only, I can submit, your lordship, that the petitioner
That's
has
not
not given
my-
a.
That is not my disability. That is unfortunate disability on your part. How can I help? If your respondents don't give you instruction, and that's it. We'll proceed with it.
It's a government school, my lord. There's no bar for the 57-year age group, my lord. It's not a provincialized school, my lord. The government school.
Nothing.
Right now, I won't be able to say, your lordship, but only with the hearing report only, lordship.
Okay. Here the challenge is to the order. Here both are under challenge.
In item number 19, my lord, the challenge was to the fact that there has to be an order pursuant to the hearing dated 2/6/2025, as well as, my lord, the directions to the government to take action as per this honorable court's orders. Now, while item number 19 was pending, the government came up with the hearing report. So there is a new cause of action, my lord, which has been challenged in item number 18.
No, have you challenged in item number 18 the order allowing the respondent number 5 to hold the charge?
My lord. My lord, I've done that, my lord, page 15, my lord. Page 15, order 27/1/2023.
Here only the order
My lord.
of 27/1/23 allowing the respondent number 5
My lord.
to hold the charge is under challenge.
And the hearing report.
No, in the second one. In the first one, only the
Yes.
appointment.
Yes.
Give me that Tonkeshwar or something.
My lord, my lord.
But Mr. Mr. M. Sharma, learned counsel for the petitioner in the above noted two petitions. And Ms. Tarangpi, learned standing counsel, secondary education department, appearing for the state respondents therein. Respondents number 1 to 4 therein. Also, none has entered appearance on behalf of respondent number 5, although notice has been held. Although service has been held to be complete upon her. Also, the petitioner By way of instituting the above note, by way of instituting WPC number
3643. My lord.
Have you six? Has presented a challenge to an order dated 27/1/2023, by which the respondent number 5 hearing was allowed to hold the charge of the post of principal of TC Government Girls HS Roman and MP School Gauhati, along with financial power to draw and disburse the salary of the staff of the said school under FR 14 and bracketed C until further orders. Also, during the pendency of the said petition, a hearing was held wherein the petitioner the petitioner thereafter has by instituted WPC number 234/2026.
The hearing report is undated, my lord. There's no date to the hearing report. It's at page 54.
Assailing order dated. The assailing a hearing report submitted in the matter by the
deputy director, my lord.
By the Deputy Director, Secondary Education, Assam, Kahilipara, Assam, rejecting the prayer of the petitioner to hold the charge of the post of principal of the said school on the ground that one ad hoc cannot be replaced by another ad hoc. Also, the facts in brief requisite for adjudication of the issue arising in the present petition is noticed as under. The petitioner was initially appointed as under Regulation 3F of the Assam Public Service Commission bracket limitation of functions bracket over Regulations 1955 while issuance of an order dated 2/1/1995 by the Director of Secondary Education, Assam. The petitioner was so appointed as a subject teacher in Assamese. Also, the services of the petitioner was regularized while order dated 2/3/2001. Also, it is to be noted at this stage that the school wherein the petition is working is a government school. Also, the dispute herein involving the respondent number 5, the respondent number 5 on the other hand, you are in the same school.
No.
Your way.
I'm in TC school, my lord.
Are the ladies also?
Oh, she's for TC.
Why don't you give her a dusty notice of this? Same school.
Done that, my lord.
Done.
Dusty was also done, but before the affidavit could be filed, the hearing report had come up. There was a direction, my lord, also. And Dusty has...
In the second case?
No, not in the second case.
Because see, what happens is, these are very technical things. We pass the order tomorrow on that count that I did not get the notice because we can't establish that the notice was served on. It's just a presumption drawn. Delivered. Delivered to whom? You were standing in the gate and you have taken the notice being Subbalakshmi. You can't say that. It's
representative. Again.
Do one thing.
My lord.
Serve the notice tomorrow. Give her a notice. We'll permit you.
My lord.
You download a copy of this order.
My lord.
And give her a petition. Copy of a petition and the downloaded order. And we'll have it on Friday. We'll dispose it of. Thursday, we'll dispose it of.
My lord. Now, what might happen now, my lord, just subject to your lordship's final observation, she might refuse to sign on the paper individually. That is a possibility that might arise.
লেখা
In that case, my
লেখা
lord,
লেখা লেখা কাটাই কিনে পৰটো খালি থাকিব ওপৰে ফাৰ্ষ্ট পেৰাগ্ৰাফটো থাকিব চাওক the issue arising in the present writ petition is as to whether the petitioner herein Muhammad Yusuf. That is troubling me, whether the respondent number 5 in fact was served or not.
no, initially the service was done through the registry, and there was a liberty also which was granted to us to file an dusty, my lord. We have done all of it.
Madam,
Lordship.
ask your director to inform her that this matter is pending. If she wants to appear, she can appear. We are fixing it on Thursday again. Ms. H. Tarampi, noticing that the respondent number 5 is not represented in the present writ petition, this court requires Ms. H. Tarampi, learned standing counsel, Secondary Education Department, to inform the respondent number 5 through the director, through the inspector of schools, Kamrup,
Yes, Your Lordship.
about dependency of the present writ petition and that the present writ petition would be taken up for final consideration on Thursday,
30, my lord.
30/5/2026 at 2 p.m. Also, the inspector of schools shall inform the respondent number 5 about dependency of the present proceedings in writing, and an acknowledgement there and a copy of the and on receiving acknowledgement thereon from the respondent number 5 shall place the same before this court on the next date of listing through Ms. H. Tarampi, learned counsel appearing for the response for learned standing counsel, Secondary Education Department. Thursday korotke iye kori dia. Please, I take kori dia. 4/5 or further hearing.
My lord.
Yes, after a long time, this matter has come.
You know, Mr.
Yes.
Goswami was supposed to,
Hmm?
Mr. Goswami.
Goswami is here. So how did this happen? How did you select that?
Second,
Yes, Mr. Decca. They say that you have done it.
We have only verified the list, Lordship. That is very clear.
Yeah, that is now District Commissioner Hailakandi is saying that everything was done by you. You
Hailakandi,
prepared the list.
Lordship, Hailakandi had sent it to the AIDC, the list, then we have verified, we have given it to the Department of Industries, who has appointed. Like, that is on record, Lordship. We can place it.
No, I only wanted that how was the
Absolutely.
post identified? Who identified the
We have not done that, Lordship.
Who has done?
Government who is appointed, we have not issued any appointment letter. We have not done anything except the verification of the persons that list the name and which were given by
What
the.
did you do?
We did only the verification.
What verification did you do?
With regard to the persons whose names were on the list, if they're the employees and those who had the qualification, what they have said, as in what is the list content that we verified, it is genuine, Lordship. And the list was forwarded by the Deputy Commissioner of Morigao.
No,
as well.
the list that the Deputy Commissioner
Yes.
forwarded.
Yes.
Where the post against which
Lord,
they have
no,
commented?
post were not done by us. We only verified the names.
The post was identified by whom?
The Department of Industries, Lordship. Lordship will.
Where is your appointment
Lordship will.
order?
At your page 35. Oh, 40. These are posts are, your lordship, at page 35.
Yes, Lordship, that,
These are the list of the posts. And the appointment order, your lordship will find at page 44. 44 onwards. 44, 46, 48. The list of the posts are at page 35.
And you were appointed in?
These petitioners were appointed in industries department. That your lordship, page 44. Sorry, the employment and entrepreneurship department.
Who is appearing for the industries department?
I am appearing, Lordship.
Huh? Who asked you to get this instruction from the district commissioner? Did we?
Yes, Lordship.
Did I ask you?
Yes, Lordship.
Well, why did you get it from the industries department when the appointment order is made by the industries department and the
Employees
Huh.
entrepreneurship.
you come to page 35.
Lordship.
34.
Lordship, in that count, Lordship, this, on behalf of the, yes, Lordship.
Come to page 35. Why is your instructions not got from the
No, that entire, the process was done by the deputy commissioner, Lordship, this.
I'm sorry, that is not correct. Page 35. The industries
35, yeah.
department forwarded the same. And down below, you will find how the thing is to be done.
Yes.
And if it was done by the industries department and the appointment orders by the director, employment and craftsman training.
Yes.
That means it's a body under the industries department, not others, otherwise. Yes. How did you appoint this person? You are the main culprit itself. Yes, that's why you're sitting there.
They are working under us.
Okay, how did you appoint them as store, workshop attendant, store attendant?
Yes, ma'am.
Not in a higher post?
Yes, ma'am. We have received a letter from the government that as per the decision of the cabinet.
The government letter dated 31/8/22.
This is of 3rd September 2022.
Okay. What is that letter?
Lordship may kindly say.
Where is the list accompanying this one? Where is the list? This is a part of this record.
Yes, ma'am.
Huh? There's nothing new here.
If your lordship comes.
Where is the list?
Well, that I am not annexed.
Why? Why have you not annexed?
Petition number 1 and petition number 2 are working under us. Petition number 2 is working under industry.
Okay, 1 and 2 is under. So where is that list given by the industry?
List forwarded by the industry department to the
Where is that?
to our
So
department.
industry department forwarded that list to you.
Yes, ma'am.
Saying that petition number 1 be appointed against this post.
Yes, ma'am.
Huh?
Yes, ma'am.
Identify.
Yes, ma'am.
Where do I get that?
That. But if your lordship comes to page number 26 of the petition, and except 2, as per the minutes, paragraph number 9. If your lordship kindly see page 26, it says principal secretary industry will notify the senior most redress any grievance, my lord.
But this was done by the industry.
After doing such exercise, we are not asking the officer there, we'll do. But tell me, who?
As per their list, my lord.
Where is that list?
The list of employees at page 36, that is continuity of the after 35, that is the list, which was forwarded to all the secretaries, Lordship, not particularly.
So where is the name of the petitioner here?
Yeah, petitioner, your lordship, at page 37, lordship could not find. Petitioner at serial number 30. That is at page 30.
It's 40.
40.
Serial number, page 40.
Serial number 30, 33. These are two petitioners, and I think one is at 41, 42, serial number 42.
Why didn't you show me this? This is the list.
Yes, but this is the list.
This was this earlier.
How did you
APR.
prepare this, Mr.?
That was the question, your Lord.
How did you prepare this? I forgot. How did you prepare this?
In that connection, Lordship, I have some instruction, Lordship. This is General Manager, District Industries and Commerce.
We don't want, this letter is issued by the industry, by the Secretary Industries and Commerce. He made the thing. How did he do it? You have brought this list from the Deputy Commissioner. What is the use of that? This is the list. How did you decide to appoint Saidur Rahman Borbhiya as a grade 4 workshop attendant, store attendant? And you claim, Mr. Manan, that you should be appointed as?
Grade 3 on the basis of
This is
my
a grade 4.
These are grade. That is the reason. And then page 37 on discussion. Please, sir. In fact, your lordship, they also in that page 35 letter, they said that as per the criteria that I
They have
already
laid down certain criteria.
that criteria in the criteria number 2, that is at page 36, been stated, the qualification of the officer to be absorbed should be equal or more than that of the considered post. So as part there, the considered post criteria is graduation. And these people are all graduate as well as other technical, your lordship, ITI and all.
Okay, how many petitioners are there?
Here three.
Three. Where is the second one?
One is at serial number 30, one is at 33, and one is at 42. 42.
Sufia Naam.
One is at 42. Supi Ahmed, then Saidur Rahman, and your lordship 42, Islamuddin Laskar.
42.
তো হয় আৰু এটা 42 এটা আছে
এটা 42
তিনটা আছে
এতিয়া শিকনা
এটা কিবা বৰ বঢ়িয়া সৈদুৰ ৰহমান বৰ
118 no, page 118. The affidavit which was submitted by the AIDC. 118. This some clarity is there, Lordship, regarding the preparation of this list. This list of which refers to subject cited, I would like to inform you that that the screening committee was constituted headed by.
Where are you reading?
Yeah.
Where are you reading?
118, Lordship. It is the affidavit submitted by the AIDC. Page 118.
Presentation গন্ডগোল আছে গন্ডগোল হয়েছে
The affidavit which was submitted by the AIDC.
118.
Affidavit in opposition submitted by the AIDC.
Presentation
AIDC is respondent number?
3, Lordship.
Para. No,
Three.
Lordship, it is annexer F. F is the letter given by the deputy commissioner Lordship.
That is the origin of the list, how the list was prepared.
Yes, Lordship.
That is not in the dispute as regard to the matter, Lordship.
That was prepared by the scanning committee and scanning committee led by the circle officer. Oh, there is no doubt on this.
Yes, Lordship.
But how did you identify this post
No.
for engaging the petitioners hearing?
Lordship, if I may say, Lordship, as in, the issue was also raised before the Industries Department was sent by the AIDC. The record says only consideration which was asked to be done was to give them upgradation on the post, which is with regard to that. They can only be upgraded as per the service rules. So if
I only want to know
there is nothing.
how you have given them, how you have identified post X for petition number 1.
That's it.
Post Y for petition
Absolutely,
number
that's
2. Post Z for petition
Absolutely.
number 3. This much.
And also
How did you do that?
that is, again, I have to submit, Lordship, that is not done by the AIDC. So I'll not be in a position to say so.
Maybe we have not been able to communicate to your respondents properly. Ask them to come with the records, complete records.
Lordship,
We have no chance you have not done.
that count, Lordship, I have to call.
Mr. Counsel, we have categorically said to receive instructions from the respondents represented by him as to the manner in which, after shortlisting of the names of the petitioners herein, so and so, the post against which the petitioners were to be so appointed came to be identified.
That was, Lordship.
I think this is not clear. Maybe they have not understood.
It's clear, Lordship.
Ask them to be here. Whoever is your commissioner and secretary, principal secretary, whoever, ask him to be here tomorrow 10:30.
Lordship, it's clear, Lordship. The order is clear.
Then why did you bring and give me this?
That Lordship, that Lordship, that was, my letter was sent to the deputy commissioner.
Why did you?
Lordship, fix a date, Lordship, any date, Lordship, I will.
I'm fixing it.
No.
Tomorrow morning, 10:30.
Lordship, I will take.
You're
it.
taking this, your authorities are taking this court for a ride.
Yes.
Why?
I will call, I will call for the commissioner, Lordship, the appointing authority, Lordship, what is the ground.
Mister, why didn't you not do it? You had undertaken, you will do it. And then you were taking time.
That, Lordship, that aspect, I got one instruction, Lordship, that's why. 2 days is required, Lordship, only 2 days.
Tomorrow, 2 p.m.
Day after tomorrow, it may be better, Lordship.
30th, your lordship, I am not here.
You're not. You need not be. We'll only have that interaction. We'll come back. We'll give you a chance. We want to know. Okay, we'll have you also. Both you are here.
Monday, your lordship.
Monday.
Monday.
So he
30th
gets-
only difficult.
Monday, it is 4.
Monday class.
Four.
Oh.
Maybe it on 5th.
Tomorrow, 2 p.m. On the prayer of Mr. J.K. Goswami, Learned
Day
Counsel, Learned Additional Senior Government Advocate,
Day after tomorrow.
for an adjournment, some advocate for completing his instructions in terms of the query raised by this court by the order dated 27/2/2026. It is to be noted that in spite of a clear query raised by this court from the respondent upon the respondent authorities, the clarification thereon has not been furnished till date. Today, Mr. Goswami has placed on record some instructions received from the deputy commissioner, which which does not satisfy the query raised by this court. The identification of the post is found to have been made by the government in the Industries, Commerce, Roman and Public Enterprises Department. However, Mr. Goswami has not placed on record any instructions received from the said authorities. Also, Mr. Goswami undertakes that he would place in the instructions from the industry, from the authorities of the industries department, from the respondents in the industries department, invariably on, you're not here on 30th, on 5. Five, 2026. No further adjournment would be permissible. In the event the complete instructions are not available, are not placed on record, comma, this court would be left with no other alternative but to require the commissioner and secretary and the principal secretary, whoever is in the helm of affairs in the industries department, to appear before this court with the contemporaneous records to assist this court in disposal of the present writ petition. Registered to list this matter again on 5/5/2025 as the first item.
Obliged.
Obliged, Lord.
And all of you sit together. If there is some other persons who have made identifications also, must kindly get that, because on 5th, if I don't get it, that's why I put it as the first item. 2 o'clock, we are having everybody here. Mr. Goswami, please do the needful.
Obliged, Your Lordship.
Yeah. Who was in 90?
My lord, it is under process, Your Lord.
Yes, madam, what happened?
It is under process.
Oh, it is under process for last around
5 years.
5 years.
Sir, received today, Your Lordship. Today. What time, sir?
Your areas are due from which date to which date?
My lord, that is 18 to 2014 to 28 to 2015.
Yeah, the 15 to 14 hobo.
Your lordship made a query in the last date as to the date on which the salary would be released.
Yes, why is this delay in receiving the proposal from the inspector of schools? The orders were passed in the earlier round. Where is that order?
It's page, my lord, 45.
Yes, this order was passed on 19th. What were you all doing? The proposal seems to have just come, 27/4/26. Why? What about the earlier period? Why was he sleeping? There is an interest of 7% already added. We will add another 2% to that. And this money will be recovered from your inspector of schools till your directorate, whoever has dealt with that file. Ms. H. Tarangpi, Learned Counsel for the petitioner has on instructions submitted that the area salary proposal in respect of the petitioner was received from the Inspector of Schools, SDC, Sri Bhumi on 27/4/2026, and the same is under process. As noticed in the earlier, in the order dated 24/2026, The petitioner praying for being authorized his area salary from 18 to 2014 to 28 to 2015 had already had approached this court by way of instituting a writ petition being WPC number 3851 2018.
15.
3851. 38 oh,
One.
3815. The said writ petition was disposed of by this court by a coordinate bench of this court by order dated 5/8/2019, directing the respondent authorities to verify the claim of the petitioner for being authorized his area salaries for the set period and to release the same to him. Also, it is seen that the petitioner had furnished the certified copy of the said order to the respondent authorities proximate to the time of passing of the said order. However, today, from the instructions furnished on record by Ms. H. Tarangpi, Learned Standing Counsel, Secondary Education Department, the respondent authorities had never processed the matter for compliance. It is only on 27/4/2026, that is after passing the earlier order, after the passing of the directions, passing of the earlier order dated 24/2026, that the matter was processed by the respondents. Also, as there is a requirement for also authorizing to the petitioner interest at the rate of 7% on the area amount, the Director of Secondary Education Assam shall place before this court as to the reasons why the petitioner's area salary proposal was not processed immediately after the passing of the order dated 5/8/2019 in WPC number 3815/2018. The director shall also place on record, along with the said report, the names of all the persons who were to process the matter after the passing of the order dated 5/8/2019, both in the office of the Inspector of Schools, SDC, Sribhumi, as well as in the Directorate of Secondary Education, Assam. The said names are required so as to apportion the interest amount on the person so responsible to process the matter. The said report along with the names of the persons be placed before this court on 18/5/2026. Also, no further adjournment shall be granted for the purpose.
Yeah. Obliged.
Item 1 dismissed. Item 2 allowed. Two lipila. My guitar was an over. Hello. Any urgent matter? Because I'll have to pass these orders. Any urgent matter?
Item 43,
Huh?
my lord.
Item
43. He's a retired principal, my lord. He has not.
I'm sorry for that. Item number 2, my lord. That's one line, my lord. He was already selected in district level selection committee, and that was forwarded to the.
If you get that regular selection, we are not barring you.
But my prayer is that, my lord, as per notification, my lord, within time limit, maybe my lord, regular selection may be made.
You are not before me. He has not made any prayer for. You have been selected by the. He has not been selected.
Not selected.
Why?
Because he is not appeared before the, not appeared before the district level selection committee.
Why?
200 appeared and 200 post pilot. I am appeared selected at 109.
And why he is not selected? Why he is not appeared?
That's by instruction. That may be.
We will not bring it up. The regular selection, we are not concerned. Whoever gets it, gets it. We'll make it clear.
But principal of Goalpara College, my lord, he retired from service, my lord, on 31/5/2017, my lord. Item 43. Thereafter, my lord, I have challenged one order, my lord. Only because of the, my lord, this letter, my lord, I have come before this honorable court again, my lord. Because my grade pay also not given to him. He joined service, my lord, at Shillong, my lord. Initially, he joined service, Shillong. Provincialized, my lord. Thereafter, my lord, after selection as a principal, he joined service as a principal at Goalpara College. But during this movement, my lord, he tried his best to satisfy the authorities, my lord.
He was in Shillong.
Initially,
Meghalaya.
Shillong, my lord.
Then?
On Lien, my lord, he joined service, my lord.
As what?
As after selection, when he joined service at Shillong, assistant professor, my lord.
Okay, some Meghalaya college.
Meghalaya College.
So he came on Lien to
as my lord, as assistant professor, my lord.
Where?
At Krishna College, my lord.
Krishna College.
Yes, my lord.
That whether he was absorbed there?
Shillong.
No. Krishna?
Yes, my lord. He have annexed all papers, my lord.
Then what happened? Tell me what happened.
After selection as a principal, my lord, he
came to Goalpara.
Goalpara, my lord.
He retired in Goalpara.
Goalpara, my lord.
Within that period of 5 years.
5 years,
of joining.
Yes, my
Now
lord.
what is the problem?
Because, my lord, he submitted several representation for.
When did he join Krishna College?
Yes, my lord. I have a release order that is.
Oh, this should be in your mouth, fingertips.
Just I am placing my page annexure.
Oh, you tell me the date. When did you join Krishna College?
After 11, join is my basic main. Yes, 3/11/2005, my lord.
3/11/2005. Okay.
In the pay scale of so, my lord.
Okay. And now when you joined there,
yes,
was your GPF account opened?
No, my lord.
No.
No.
What did you do?
Because, my lord, after coming from Meghalaya to Shillong, in Assam, my lord.
Now, when you joined in Krishna College, after a selection you joined, you had come by through proper channel.
Yes, my lord.
Now, whether that service has been added, have you given the benefit of that earlier service as an assistant
Not
professor?
given. That is why, my lord. Several representation.
There is much steps left. We'll hear this matter.
Just, my lord, I am placing by annexure 12 page.
Okay, got it.
Just,
I did not read it yesterday. We'll place it. We'll do it.
Just, my lord, first.
So first you will have to give you pay protection. That period has to be counted.
Yes.
Then we will have to say that you are a provincialized. Have they filed an affidavit, government?
Not filed. Kalipiraj Lordship page 37. Just
we will.
Very short affidavit. Just representation.
Not today. On the prayer of Mr. H. Das, Learned Counsel for the petitioner, registered to list this matter again for hearing on 14/5/2022. Any urgent matter?
24 to 26, my lord, these are PA protection matters. I'm not seeking a hearing today, my lord. If a date can be
Because
fixed.
I'll have to pass this 5 orders.
I understand.
22 to. And your
24,
order is
25,
also
26.
pending.
25,
Yesterday's.
26.
When do you want it?
My lord, second week of May or third week of May, probably. After 10th, my lord.
Those matters. As prayed for by the Learned Counsel for the parties, registered to list this matter again on 19/5/2026.
My lord.
Matter be not treated as parted and or tied up matter with this court any further.
No, I don't have 45. No, this is I don't have 45, madam.
45, yes.
No. Is it regarding promotion from the post of assistant engineer to executive engineer, madam?
That case.
Yes.
45 PD. Pakibo, due to paucity of time. Individual one, paucity of time. It will start. Yes, Mr. Whatever.
And here, madam, the last DPC was held on 60/25, madam. Here they say that due to, madam, pending of department proceeding and criminal proceeding, madam, his name was not considered for promotion, madam. So even my name has not been.
Captain seal cover.
Yes,
also.
madam. And it is a department proceeding is going on since 2017, madam.
That has not been concluded.
Not concluded.
So you want to say that ad hoc promotion has
Yes,
to be
madam.
going to be.
At
Yes.
least my time and.
You are there.
Item number 30, my lord.
Oh, we are coming, we are in item number 45. Okay. On the prayer of the learned counsel for the petition, raise the item number 45, registry to list this matter again on. board
Would not be sorry.
21 here, another 40 will come from there. My
lord, item number 30, my lord, possibly people on Thursday, my lord.
Not possible this week.
Next week,
Next
madam,
week,
because they
next
have issued a so cause notice.
Next week.
During the pendency of the matter, my lord. How can-
Okay, if there is so much urgency, we will hear every matter. Come, yeah. Matter actually.
45 to go, 44? Achha.
None appears for the petitioner on call. Registry to list this matter again. For the ends of justice, registry to list this matter again after 2 weeks on a date 2 weeks by. Yeah.
20.
Digita adjourning is it, sir? Yes, what is it?
See, this case was provincialization of the petitioner school lordship.
Huh?
The provincialization of the school of the petitioner lordship. His school was recognized on 18.
Yes.
And sometime in the last file over it.
The prayer of Ms. N. Foucault, learned counsel for the petitioner, registry to list this matter again after 2 weeks on a date 2 weeks by. Yes. Yeah.
Wait, please, your lordship. Lordship, sorry, lordship. Item number 20, lordship. We have already returned back the net.
I've said none appears. For the ends of justice, matter is fixed afterwards. That's all. Mr. Sina had made a mention in the morning.
Lordship, I think there will be paucity of time. I'll just place before your lordship 2 judgments.
No, today not.
Yes.
I have to pass
Just
5
for-
orders today.
Just for your lordship's consideration. And
You can put it here.
Yes,
Floyd
yes.
Awakening.
Yes.
As agreed to by the learned counsel for the parties, registry to list this matter again on 18/5/2026. You just give it.
Yes, sir.
Yes, what is the urgency?
Lordship, there is no urgency, lordship. Lordship, I in fact left your lordship.
No. Everybody says they have urgency, so why should I? I'll also sit and I'll do it. What is there? Nothing. Yes. Affidavits filed. No rejoinder is.
Detail affidavit is not yet filed, your lordship.
Response number 4.
I only brought on that.
Mr. Ghosh, you want to file an affidavit or we'll fix it for you?
There is a proposal that was sent to the government. So I have no status. The
Commissioner and Secretary has, Commissioner has filed the affidavit.
Yes, okay. Commissioners.
It's not a whereas affidavit, lordship, only to bring on record certain documents, lordship. They filed the affidavit.
Mr. A.K. Ghosh, learned Standing Council, Panchayat and Rural Development Department submits that an affidavit on behalf, you will not filing.
I'll seek instructions and because the proposal has gone, I don't know.
Submits that, that no further affidavit would be filed on behalf of the departmental authorities and accordingly, the matter be taken up for final consideration.
If needed, I'll file an.
We can't have ifs and buts. You tell if you want to file, we'll file, otherwise we'll not.
See, the proposal has gone, I do not know the status of the proposal, that's the thing.
Why? Well,
I have sought for instructions, but those are awaited. So
who is not giving you instructions?
it has to come from the government regarding the
Government.
status of the proposal.
Who is the authority in the government to give you that instruction?
Signatory. Means it pertains to constitution of a sale and also creation of post.
Chief engineer.
Yes, Lordship.
If the government is not giving, we'll record it. Lekha, that, we'll record it. As agreed to by the Lana Council for the parties, registered to, registered to list this matter again on 18/5/2026. The parties are at liberty to complete their pleadings in the meantime. Yes. What is your urgency?
Urgency, Lordship, kindly see the last order, my lord, and thereafter, my lord.
Due to paucity of time, matter could not be taken up.
Last order, your Lordship has passed an instruction.
I don't know, last order is that.
The order before that, Your
Before
Honor,
that.
is trying to indicate.
Okay.
So that instructions I have.
Yeah, what is your instruction?
My instruction is that initially what has happened, we have on the last occasion, he has made two grounds that he was not given the head of the department in charge. Because there were some issues with regard to a construction.
But the similarly
Yes.
situated persons
No,
have
that
been
is-
given.
That is the reason. Now, what has happened, Your Lordship? This fact was not there. It's, so I have got this fact. Earlier before that, there was a altercation of wrong with the lady professor of the college. And on that basis, Your Lordship, there was, this order was passed and so cause notice have now been issued to him. And he was directed to file his reply. And before the Bihu vacations, he approached the authorities and sought more time to file the reply, and his reply was supposed to be filed after the Bihu vacation. As of today, I don't know whether it was filed or not, but last two days back, it was not filed. So that with regard to the so-called with regard to the other two persons where, Your Lordship, what has happened? The other two persons were also with regard to the same construction committee. They were offered because he was not offered because of this issue, not with regard to the construction. Construction was supposed to be completed within a period of 6 months on their own.
Focus not it, so. Now, Lordship.
Now that is the reason, this is the reason why he has not been given. The other two were offered, one of them has accepted, the one has refused.
Now, Lordship, kindly see.
Just a moment. And in fact, if Your Lordship, his replies is acceptable on this so cause, they will, I have talked to them, they said that let
What
him
is the shukos? With reference to the governing body resolutions and the meeting cited above, you have been placed under ban from taking any advisory role in the college affairs effective 10/9/2020. As the RUSA Enquiry Committee, what is this RUSA?
This committee inquired with regard to the construction company.
So, this is with regard to
That
construction.
RUSA. There is also the altercation with a lady.
This is not here.
But I have been told, Your
Why
Lordship.
it's not here?
They have given me the instructions over phone.
Yeah.
Anyway, that is there.
You have a
I've got
copy.
a copy.
So here there is nothing. If this person is proceeded, why the others are not being proceeded?
No, other, Your Lordship, no, this is the reason.
Others don't have a lady
I'll
allegation.
do one thing, I'll, Lordship, I'll bring the, that particular record with regard to the altercation and other.
No, we want that if there is a proceeding against this
Yes.
person,
Mhm.
why this same proceeding is not there against the two other?
No.
RUSA.
That is true.
Then?
That is true, but here with his, as per my instructions, the proceeding is with regard to
That he
the
has not
altercation
yet,
with
that,
the-
that Mr. Sharma has not yet received. This is the only show cause you got.
I do not have the copies, Your Lordship. I have been instructed over the phone.
Now, this is a ban by the governing body resolutions. Okay, where is this governing? Is it on record?
Now,
11,
Now, Lordship.
10/9/22 is it on record?
Yes, yes. Lordship,
Where?
kindly see
Where?
running page 26.
Ah,
The governing body of the said college was allowed to withdraw the said objectionable letter, that is running page 26 in my petition. And the said banning order was not existence while the.
Mr. What is this?
It means, my lord, running page 26, my lord.
Connection with hostel
Hostel
super
selection.
election.
And petitioner wanted to know how this election process was done. And accordingly, the principal felt that he has used some offensive word, and accordingly, he was debarred from financial advisory rule in the year 22. Subsequently, in the running page 26, the governing body of the state college was allowed to withdraw the same. And the said order, if your lordship kindly see, in the year 2024, the petitioner was appointed as the HOD of the state college. Now the order was passed, running page, your lordship kindly see 43.
11/5, where I get it? 11/5.
Yes, my lord. 43 running page, the impugn order, lordship. For a moment, my lord. That was, lordship, kindly see, there are.
Just give it. 14/8. Is the governing body resolution 14/8 on record?
That was the record, that was the deputy in operation they have filed, my lord.
Mr. Manan, this seems to be all pertaining to that Rusa, not the girl.
In fact, your lordship, I also indicated that if that is Rosa, then how these two persons were granted. One of them accepted, one did not. Then they said, no, this is with regard to altercation.
Where is this GB meeting dated 13/8/25? Is it on record?
This is not on record, my lord. Only.
Mr. Y.S. Manna, learned counsel appearing for the respondents number 3 and 4. On instructions has submitted that the petitioner has not been debarred from holding the post of HOD and or taking up positions involving from taking any advisory role in the college affairs, not on the basis of the ban imposed with regard to the allegations leveled against him pertaining to the construction activities carried out in the college, right? He submits that there is a further allegation leveled against the petitioner by a lady assistant professor of the college, which had led to his ban which had led to the debarring of the petitioner from holding the post of HOD as well as other financial roles in the college. The said position is disputed by Mr. S. Sharma, learned counsel for the petitioner, and he submits that it is only on the basis of the recommendations of the Rusa inquiry.
Yes, my lord.
Anything else?
No, nothing.
Then why dare you?
My lord, I just point out one thing I will clarify, my lord. If your lordship kindly see, if your lordship permits me, my lord, the running page 43, there are only 2 reasons mentioned for non-approval of the petitioner. Now the respondent has presently, he has to supplement the order by new fresh grounds.
Lisa. Of Rusa inquiry report, right? Rusa inquiry report. Who's up? Mr. Manna shall, on the next date of listing, while placing on record the inquiry report, the show cause notice is served upon the petitioner, along with the relevant governing body resolutions adopted. Governing body resolutions.
Given here, many resolutions have been given.
In the.
In the letterage. I
Four,
think one of them.
four, five.
Five.
You're not mentioning you.
Yeah, I'll get all.
And so and so. Resolutions. So, in the event, the only allegation against the petitioner is pertaining to the RUSA inquiry, RUSA, RUSA inquiry report. Mr. Mannan shall also clarify as to why the other two HODs, other two professors, associate professors,
That's right.
who were also involved with regard to the implementation of the schemes under RUSA, were not proceeded against. Registry to list this matter again on 19/5/2020.
Lot. I'll get all this.
Correct.
Record itself, that will be that.
Mr. Sharma, have patience.
No, my lord, I have patience, but now lordship kindly see for a moment, if your lordship permit me. The impugn order was passed on two grounds. Now they have, while the matter was pending before this honorable court, how can they issue the sober's notice to affirming the departmental proceeding? There was no going on departmental proceedings still going on. Subsequently, now they are trying to supplement.
How long will you take to make
Yes, my lord.
submissions?
That is the
How long will you take? 5-10 minutes?
No, no.
15 You submit. We are here.
Yes,
You submit.
yes, my lord. Now, lordship kindly see.
We'll hear the matter.
Yes, my lord.
We are disposing of the matter.
My lord.
And if I don't get anything here,
My lord.
I'll impose cost of 50,000 for wasting the time of the court.
Now, lordship kindly see the impugn order, my lord.
Yes, what is your case?
My case is that my lord.
Others can go. We'll only hear this today. Okay, who are you?
My lord, I am the petitioner in this case, my lord.
No, you are the petitioner. Who are you?
My lord, I am the HOD of this particular college, my lord.
You are HOD. Which department?
I am the earlier I was the HOD.
You are the HOD or you were the HOD?
I were
Oh.
in this college, my lord.
What are you? When did you get recruited?
Now, lordship kindly see the order, my lord. The impugn order, lordship kindly see. Running page 43.
So you want an approval,
Yes, my lord.
direction to approve you as the HOD. Right?
Yes, my lord.
Sipsagar Girls College.
Shivahaga Girls College. And I was working for a period of 1 year.
Now tell me the facts.
Now,
Complete
the
facts.
fact of the case, lordship kindly come to, if your lordship permits me, come to lordship kindly, the running page 43, my lord. The impugn order.
What is the manner of appointment of this?
The procedure laid down, that is annexes number 1. The governing body of the state college office, there was an office memorandum that is running page 23, my lord. The process laid down how the HOD of the college was to be appointed. And that should be rotation basis, my lord. Every 3 years, it should be rotated, my lord. That is the running page 23, my lord.
Okay, then what happened?
What happened, my lord? Thereafter, the petitioner was appointed in the year 2024 as a HOD of the governing body of the state college. Subsequently, what happened, my lord?
HOD?
HOD of the education department of the Sipsagar Girls College, my lord.
When were you appointed?
In the year 2024, I just.
24 month?
Month, my lord. I just annexed that running page. That was 18/6/24. That is annexes number 9, my lord.
Page.
Annexes number 9, running page 40. The petitioner was appointed as a HOD of 18/6/2024. Subsequently, what happened, my lord?
the petitioner working as a HOD of the 1 year. Subsequently, the some of the newspaper, it was published that the RUSA, during the tenure of a HOD of the governing body of the state college, the petitioner has committed or misappropriated the money of the RUSA fund, which was allotted in the name of the college.
Where do I get it?
Yes, my lord. That was published in the, my lord, that was published in the newspaper. And subsequently, lordship, on the basis of the said publication, the governing body has constituted two inquiry committee that was filed by the respondent principal, which was filed as an exercise. They have filed in their affidavit in opposition. Now, lordship, kindly see, on the basis of the said two inquiry committee reports, the petitioner was disapproved as a HOD of the state college. Running page 42, my lord.
Then
Now, lordship, kindly see for a moment. Running page 43. There are only two grounds. That is 4A, that the petitioner was diverted from any advisory rule in the college as per resolution number 11 GB meeting dated 10/9/2002. Now, my lord, I have just for a moment, if your lordship pause, that is the show cause notice relying that the petitioner was diverted as per advisory rule dated 10/9/2022. That was the one ground. And the second ground is that there are investigation and irregularities going on as per RUSA project in our, especially during your tenure as a coordinator. Now they have down two grounds, and now lordship, can you come to page?
Oh, what are the two grounds?
That is the two grounds. One ground was the petitioner, lordship, kindly 43, lordship, kindly come to the that third line, my lord. The under resolution number 4A, did our college as your debut from any advisory rule in the college as per resolution number 11 GB meeting dated 10/9/2022. That petitioner was debarred in the year 2022. Any advisory rule. Second ground is that the inquiries have been going on at various levels to investigate the alleged irregularities in the implementation of RUSA project in our college, especially during in your tenure as the coordinator.
Okay.
Now these two grounds. Now let's kindly come back to the running page 26. These are the letter the petitioner was allowed by the governing body of the
This is not the allegation now.
Now,
The allegation is
that point also.
fine. Let us proceed further.
Lordship, kindly come that point 26.
So these are the two grounds wherein you have.
Yes.
What is the stand?
Now my stand is, lordship, kindly see. Running page 26, my lord. That was the objectionable grounds they have taken.
Mr. Counsel, that is not with regard to RUSA.
RUSA.
That is not with regard to RUSA.
My lord, with all due respect, my lord, there are two grounds. One ground is the petitioner was diverted from as per resolution number 20 in the year 2022. That was the first ground.
Where is that resolution?
That resolution not.
So what is the allegation against you in that resolution?
In the resolution that the petitioner had committed, my lord, petitioner was diverted from advisory rule as per resolution number.
Show me that resolution. Where is that resolution?
My lord, that resolution.
Where have you stated that the 22 resolution is for a particular purpose? Where is that?
No, my lord, I have already categorically stated in my affidavit in.
Mr. Counsel, what is the allegation against you in 22?
That lordship kindly come to my annex affidavit writ petition, my lord.
We are in the writ petition only, not
Yes,
gone anywhere else.
my lord.
Please, where is it?
Yes, I have categorically stated.
Yes, Mr.
Yes, 12, my lord.
Page 12.
No, my lord, running page 10, paragraph number 10, my lord.
Paragraph number 10.
Yes.
Paragraph number 10 or 12?
Paragraph number 12, sorry, my lord. I'm confused.
Okay, what is this advisory role. What is that allegation in 22?
Yes, but that was the
In fact,
advisory.
I've got a letter in.
Now,
I mean,
Lordship.
his letter, where he has admitted this fact. But I don't have all the records with.
Fine,
that-
we'll
that-
come to
that
you.
part-
We'll come to you. We'll
that
come
part
to you.
I have
Yes,
got
where
at
is
least
your,
one.
this 22, what is the allegation?
Now, Lordship, kindly running page 5, my lord. Ekdom precisely, I have written that point, my lord, in my
Right.
paragraph number 5, my lord.
Okay, 5.
Yes, my lord. That what happened, my lord, on that day, 6/2/2022, a notice was issued for filling up the warden post of the said college. Accordingly, the petitioner applied
But
for.
this has got nothing to do with the selection.
Rusai.
Hmm?
This is nothing to do
Now,
with Rusai.
now,
Rusa.
exactly, my lord. This is not connection with the. Now, my lord, this is not connected with.
You
the
say that 26, the matter was closed.
close.
Okay, fine. What about Rusa now?
Now I come to the Rusapa. Now, Lordship, kindly coming to the my affidavit in opposition, my lord. Now, there are two, my lord, inquiry committee, which was formed by the governing body of the state college. The state two governing bodies committee's report was forwarded to the director of the higher education department and the higher education department for final steps. Now, the 3 members committee was constituted by the.
Oh, what is the report? Where is
Yes,
the report? Show me the report.
Yes, my lord.
What is the finding against you?
Yes, the finding, Lordship, kindly come to running page, my lord. 97, my lord. That the incomplete works of computer center at Boniabari campus as per plan estimate prepared by PME is to be completed from their own source to bring a logical conclusion to the long-standing demand of the local people so that the glory of the Shivsagar Girls College remain intact. And active involvement of PWD officials should be ensured to guide the PMU to all technical materials instead of engaging consultants from outside. Now, the second point, Lordship, see. As there are some deviation found in the laboratory building in both civil and electrical construction, the SD money deducted from the contractor should not be released without rectification of the defects, although the defect liability period is over. This direction was given to the contractors because it is a work of the contractors. The petitioner, no doubt, as a coordinator of the said college, but the direction was given to all the PMU members. Whether it is liable, my lord, to a person who has been removed from the said post.
Have you been given a clean sheet now that you are not involved in any of the, you are free from every allegation?
Yes, my lord.
Where is that clean sheet?
Yes, my lord, I have already.
Where is that clean sheet given that after the inquiry there is nothing against you?
No, my lord, the clean sheet is not given against me. There are only one words, my lord, indicate that all the PMU members.
Okay, where is that list after the inquiry? What is the finding the governing body has come to that you are not involved, that you are not liable to be, you are not blameworthy? What is the material?
My lord,
is there any material?
There was no, even though there is no material, my lord, if your lordship kindly the RUSA guidelines see, my lord, the RUSA guidelines clearly stated that it was the work of the principals to monitoring the every work.
Okay. We'll ask the director of higher education
Yes,
to look into the matter.
Lordship, page 99 forum. This is the whole issue is 2 issues we have already annexed. There's a type copy of that governing body meeting, one of the meetings.
No, did you find anything against him in the inquiry?
Yes, he was the coordinator, and this is indicated here. That these are all the, in fact, in the report itself, I'll point out to that. But this is the decision taken. That is why I'm just pointing that on this basis, your lordship, it has been. Here it's, he also sent a letter of apology also. That is also there. That has also been mentioned. Dr. Rita Borkakoti. So he has done something against Rita Borkakoti, and then ultimately after there was some letters, then he issued this letter, Rita Borkakoti, and in this case, your lordship, he was barred from holding the post of head professor in accordance with the ban. It has been stated here.
Now you have done inquiries. What is the material against him?
With regard to Rusa, Rusa inquiry, your lordship, I have given here. All the inquiries have been annexed.
Has he been implicated?
Yes.
What steps did you take thereafter against him?
Thereafter, there was a direction from Rusa that the work should be completed within a period of 6 months from that day.
No, what's
The
the
work that has-
departmental proceedings against him?
Proceeding against him
Then-
is with regard to the other part. That is with regard to the data.
That is
of
not
work
on record.
That is why I said I'll bring that.
He does not want that.
Then how I can, your lordship, suddenly.
No, if that is there, it is not that it had come up
No,
yesterday.
yes,
It is
because-
there for a long time.
Yes, it is true, but.
And when did that allegation surface? After
This
the
allegation
passing of
surfaces
this
2023 itself.
23
And
itself.
2020.
So why-
Meeting has taken this.
So 26/11/3/26, when we passed this order,
Yeah.
why that instruction had not come on record? Why the college authorities have not placed that material on record? And the show cause that has been issued, there is nothing against him.
Basically, your lordship, it was on the part of
Rusa.
But this part, no, it has not been given totally, but in this page 99, it is indicated.
What?
Page 19.
That lady's thing.
Lady, that doctor lepology has been made, but specific it is not there. It is on the basis of a governing body meeting on 13/8/2025. This is the translated type copy.
Let us read the SMS one where
So here, the next page is the SMS. So they say that this was
you
continued.
come to page 101.
Yes.
Dando number 2. Read that.
আজি সভায় অসমৰ বিভাগৰ শ্ৰী সংগীতা হাজৰিকাৰ
ৰন্টু গোহাঁই।
He is Rontu.
ৰন্টু গোহাঁই। মুৰব্বী অধ্যক্ষ নিৰ্বাচনৰ সম্পৰ্কে পৰিচালনা সমিতিৰ সভাপতিলৈ এখন read that, Mr. Sharma, read that.
তাৰিখৰ কোনো সভাৰ আলোচনা মৰ্মে উঠাই লোৱা হ'ব।
পত্ৰখিনি
হয় ছাৰ। শিক্ষা বিভাগৰ সহযোগী অধ্যাপক ডক্টৰ ৰন্তু গোহাঁই মুৰব্বী অধ্যাপক নিৰ্বাচন সম্পৰ্কত পৰিচালনা সমিতিৰ সভাপতিলৈ এখনি পত্ৰ প্ৰেৰণ কৰিছিল। উক্ত পত্ৰখিনিৰ ওপৰত আজি সভাত আলোচনা কৰা হয় আৰু উক্ত আলোচনাৰ অন্তত সভাপতিয়ে কয় যে তেখেতে পূৰ্বৰ অধ্যক্ষ ডক্টৰ ৰীতা বৰকটকীয়ে যোৱা অমুক তাৰিখে তেওঁ বিচাৰি এখন পত্ৰ কৰিছিল। এই পত্ৰৰ ওপৰত ভিত্তি কৰি তেখেতক তাৰিখে এখনি পত্ৰযোগে তেখেতে ইংৰাজী তাৰিখে প্ৰেৰণ কৰা হোষ্টেল অধীক্ষক বাছনি বিষয়ক অভিযোগ সম্বলিত মূল পত্ৰখিনি যোৱা 15/6/2023 তাৰিখৰ কোনো এখন সভাৰ আলোচনা মৰ্মে উঠাই লোৱা হল বুলি অৱগত কৰিছিল।
পৰৱৰ্তী সময়ত
পৰিচালনা সমিতিৰ উক্ত পত্ৰখনৰ ওপৰত আলোচনা হৈছিল আৰু 14/8/24 তাৰিখৰ পৰিচালনা সমিতিয়ে বৰকটকী 23/6/23 পত্ৰখন সেইদৰে গ্ৰহণ কৰিছিল যদিও উক্ত পত্ৰত নিষেধাজ্ঞা উঠাই লোৱা সম্পৰ্কীয় কোনো বিষয় উল্লেখ কৰা হোৱা নাছিল। ইয়াৰ উপৰি যিহেতু ৰুচা সম্পৰ্কীয় বিভিন্ন অভিযোগৰ ভিতৰত তদন্ত।
So when the lady is not interested, why are you all interested?
Exactly, madam.
The lady is presently the head of the department. She is the head of the department.
He is the head of the department.
Now, my lord, now he is the head of the department.
He means that lady.
Lady, my lord, sorry. She is the
He is now the
head of the department.
So there is no allegation on her part.
Yeah.
Okay, Mr. Mannan,
Lordship.
appoint him as the head.
Your lordship, we have.
You have not satisfied us.
Whether she has, no, your lordship, পত্ৰখন এইদৰে গ্ৰহণ কৰিছিল যদিও উক্ত পত্ৰখন নিষেধাজ্ঞা উঠাই লোৱা সম্পৰ্কত কোনো বিষয় উল্লেখ কৰা হোৱা নাছিল। They did not take any decision with regard to
That
withdrawing
is
the
nothing
ban.
there. Why should he be prevented?
ইয়াৰ উপৰি যিহেতু ৰুচা, then the ৰুচা comes. Both together, taking together.
But Mr. S. Sharma at length also heard Mr. Y.S. Manna. Mr. Y.S. Manna, Learned Senior Learned Counsel appearing for the college for the respond number?
Respondent
2 and 3 shall place before this court the exact reasons as to why the petitioner
is 3.
3 and 4 as to the exact reason as to why the petitioner is not being allowed to hold the charge of the post of hold the is not allowed to function as the head of department of education department of Sagar Girls College. Full stop. The said instruction be placed on record on the next date of listing. Registry to list this matter again on. On 22/5/2026 for further hearing.
If required, your lordship, I may file an additional affidavit.
Mr.
bringing on
Manan
record.
is at liberty to file an affidavit, additional affidavit to bring on record
If,
any further developments taking place in the matter, if so advised.
Deeply obliged, my lord.
Item 44 may come up in any date in the next week, your lordship, as part of.
Ask her, she will give you the date. Don't worry.
Part of.
I have some 5 orders to pass. That's why I thought I'll rise a bit early, but what to do? Young guy, have their own.
My lord, I am extremely sorry, but
You need not be sorry.
there is a pressure on side of the petitioner, my lord, because they have issued this.
You have petitioner 1 pressure. I have
My
45
lord,
petitioners.
I am sorry, my lord, that for purpose, my lord.
Now, the only problem is that it will remain.
Yes, my lord. This is, my
Come
lord,
on and just look into it.
my lord.
If there is something
Sure.
serious,
I have in fact advised them that if you don't find anything, why don't you?
why don't give it?
I have advised.
But my lord.
But don't
I'll bring-
precipitate the matter.
Yes.